Chris, who is going to open our proceedings.
Oh, yes.
Thank you, Chris. In the early summer of 2007, when the realization began to dawn on me that I might actually have to leave my happy home at Duke to start a brand new law school here at UC Irvine, I panicked. First, I envisioned a sort of a Judy Garland, a Mickey Rooney musical, Catherine and Irvine start a law school with singing and dancing. And that caused me to panic a little more. As wonderful as UC Irvine is as a university, how could we possibly create a law school with an intellectual community that would rival what I had known at Duke and before that at the University of Southern California? Then I calmed down and started dreaming about what kinds of intellectual community we could build in this sunny, if slightly anomic, corner of my home state. We thought about blending really first-rate interdisciplinary study, which Irvine was already known for, with a truly deep commitment to training future lawyers. We wanted to break down the idea, which is all too pervasive in American legal education, that there was some kind of trade-off between superb theoretical, critical, interdisciplinary, historical, sociological scholarship, and caring deeply about training lawyers in what most of our students wind up doing, which is not what we do. And I think that we are well on our way to doing it. The faculty, the graduate students, and the administration here at UC Irvine are exceptionally fine, and their work has helped to make UC Irvine a wonderful home for a law school with real ambition to be a center of intellectual inquiry in interdisciplinary and theoretical ways. Optimist that I am, in my wildest dreams, I couldn't have imagined a better inaugural year than the one we have had. And I could not imagine a better inaugural interdisciplinary event than the one we commenced this morning. I have known and admired many of you through your work or personally for a long time, and I'm thrilled to discover the work of others whom I hadn't known. Your being here, you're sharing your brilliant papers and having a weekend of conversation, and the conversation is really what the high point of this conference will be, I think, could not possibly be better for an inauguration of what we want to do here at Irvine. This gathering of people and ideas promises to shape the way many of us and many others who will read the papers in the UC Irvine Law Review in years to come will think about what legal history is and what it does, both for the legal profession, but also for inquiry way outside of law and indeed history. Your presence here and the tapestry of ideas that your papers present would not have occurred without the effort and ingenuity of one person, my colleague Chris Tomlins. We've hired a number of wonderful faculty here at UC Irvine Law School, but none that I treasure more or feel more fortunate to have as a colleague than Chris. He embodies in one person what I dreamed we might create at UCI. Having Chris as a colleague is like having entire sections of the Library of Congress as your friend. I've gotten some credit for organizing this event that I really don't deserve. You're in this room because of his creativity, his encyclopedic knowledge of the field and of everybody in it, and his generosity of intellect and spirit. Please join me in thanking Chris. Now it's my pleasure to turn the floor over to another person who has been an inspiration and the very best kind of friend for many years. Dirk was a law professor at the University of Wisconsin when I was just a young lawyer with no status other than being a friend of a young scholar whom Dirk was mentoring. But he took me under his wing as well and played a much greater role than he realizes or will admit in convincing me that I too could become a law professor. As a person and as a scholar, he's truly extraordinary, so it was particularly wonderful to have him here at Irvine to inaugurate this inaugural event.
My job is to do the introductions for this first panel. This is, as I understand it, a conference about what Thomas Wentworth Higginson, the 19th century abolitionist and publicist, would call the newness, at least the newness in legal history, about the next big thing. And it's appropriate that it occur here at UC Irvine, where Chris Tomlins and Catherine Fisk and Erwin Chemerinsky and all the others are creating the newness in legal education. I look out at this audience and I really think you don't need long introductions of our panel members who are known to you all. So I think what I'm going to do is do a very short introduction and then maybe try and set, in my own personal terms, the scene for what, this panel. I'm thinking of it in part based on on a very long flight last night, what the papers, how the paper spoke to me. So think of this as a kind of lagniappe of the papers, you know, sort of the taste that, you know, and I hope it doesn't sour you, because it shouldn't sour you because the papers are really good. Anyway, okay, the paper givers, just briefly for those few of you who don't know them already, are as follows. Stephen Wilf, who is actually going to be channeled by Chris Tomlins because of the volcano in Iceland, is one of the wonders of recent days. He's now someone who works in 3 radically different fields: the social history of the American Revolution, the history of Jewish law and mysticism, and intellectual property law. His essay offers a guide for the perplexed, and it's really very impressive. Let's see, who's next? Kunal Parker. I can't say much about him because he's my own student. So I feel kind of silenced by that.
Burn it in.
Burn it, no, I do that all the time. Kunal holds a PhD from Princeton. He holds a law degree from Harvard and an undergraduate degree from Harvard. He is about to publish a history of custom, the common law, and history of the sort of triangular relationship between them through the 19th century. He's the only graduate student at Princeton I know who went and took graduate courses in the philosophy department at the same time that he was finishing his, working on his PhD. Norman Spaulding teaches at Stanford Law School. He works in several legal areas, including the history of legal ethics, and he has clearly become immensely learned in Lacan and Freud. He shows how difficult it is to think seriously, to use well that ubiquitous historian's term, resistance. And Marion Constable, who teaches in the rhetoric department at Berkeley, lives at the border between legal history and legal theory, which is why she belongs in a rhetoric department, I think. And she is the author of 2 prize-winning and quite wonderful books. Okay, so let me quickly do a little scene setting, call it my lagniappe. How to describe the present moment. I can only speak for myself, and let me avoid, or try to avoid, the universalizing we. 30 years ago, as a graduate student, I worried that doing history was either inadequate sociology, or worse yet, that I existed to provide easy examples or instances that sociologists or social theorists would do the real work with. 20 years ago, I wanted to be an anthropologist. That is, how to do legal history as ethnography. 15 years ago, I discovered that every other discipline was going through a methodological crisis, one effect of which was to lead them to embrace history and historical ways as a kind of salvation. Meanwhile, and this is, I think, the theme of this panel, of the papers of this panel, I was always reading law through the lens of the Austinian performative. I knew as a law student that legal speech did things. I remember the phrase, "it is so ordered," as a terrifying sentence for me. And like Marianne, I love the cacophony of speech acts. Importantly, I dare say, I guess even here we, love our subjects, love the weirdness of legal history. You know, Bruce Mann's Men in Debtors' Prison taking time to write and even more to try to live by their own constitution. I love lawyers' fights in trials, the weirdness of what they do and say. I love trial transcripts, even as I suffer with the miseries of witnesses trying to make their words sound, and sound is crucial here, legal. I also love the fun of deciphering the arcane. What on earth John Norton Pomeroy thought about specific performance, how to read an equity petition. So before we, and here I mean you, not me, get all wrapped up in metas and ultimate realities, let's not lose sight of the joys of our practices. Stephen Wilf has me dead to rights. You'll hear more about that through Chris when he talks about archive addiction. Like all addictions, it's always disappointing, it's never enough, and I always feel the need to go back for more. But in terms of my life as a historian, once I extricate myself momentarily from archives, including archives I construct in my head or assemble in my computer, what then? Well, then I live in historiographic time. I struggle against past interpretations. I situate them in their worlds. I want to kill them, gently and metaphorically. I know that what I think about and why I think it will eventually be known, if and when anyone cares, or reduced to my times. But still, older generations, older works of legal history fall into my thoughts, fill my thoughts. Anxieties of influence, anxieties of absence. There's nothing worse than finding oneself absorbed in a subject lacking a historiography. And when that happens, of course, I make it up. Anxieties of triviality, anxieties of megalomania. And of course, I read and I read and I read, which you'll hear more about what that means in these papers. When I read, I'm doing many things, making many kinds of inferences or guesses, leaps of faith. I think a lot recently as I work with trial transcripts about how witnesses and lawyers must have sounded. I think about class and race and gender, that's so last century, I know. And intelligence and experience in craft. I worry a lot how lives were changed because of the law, again, so last century. I worry a lot, here comes the archives again, about how I select what to read, and once I've selected about what I focus on, which paragraphs or phrases I worry about. I worry about exhaustion and boredom, about everything I don't read because I'm bored or tired, or because nothing in the historiography or in my experience has sensitized me to look at it. I take it this conference will be a continuous opportunity to be resensitized to new things. It's work and what I do, and it's legal history, or at least my legal history, in the present moment. So we begin. Chris, you want to start?
It's actually a great privilege and a pleasure for me to have the opportunity to read Stephen's paper for him. I know he's extremely disappointed that he could not be here. He felt extremely guilty that his paper arrived less than 24 hours ago. I know that some of you may have read it, many of you will not have had an opportunity. In many ways, it's an unfinished paper. It's almost a series of fragments of irony, whimsy, and humor interspersed with very, very deep learning. As I read it myself, it reminded me irresistibly, the voice that was in my head reading it to me was none other than Ira Glass, of all people. It has a kind of This American Life quality to it, as I will try to convey. Janus must surely be the patron deity of legal historians. For regular historians, we are a subspecies of intellectual historians, readers of specialized texts. We originally defined ourselves as casuists, who specialize in cases and statutes. While this description is certainly rather limited and cannot describe the varied activities of legal historians today, we still resort to claims that we can read certain texts with technical skill. Although these texts are not arcane, it is a rather old-fashioned assertion of a guild monopoly, which surprisingly still often works. For our non-historian colleagues and law faculties, however, we turn our other face towards context. We stake our authority upon knowing the period, deeply situating law in the particularities of a specific time and place. These two faces are presented at different moments and to different audiences, historians and lawyers, and therefore some of us have become as comfortable in our shifting dual identity as any minority group. While there are legal historians who put the accent mark on the first half of the phrase and others who consider themselves truly part of the historical fraternity, most of us are simply artful dodgers of one sort or another. This is not surprising, since we have embraced what Henry Louis Gates calls a two-toned approach for strategic reasons. To use a Chicago metaphor, we navigate our way down the midway, shifting between text and context, between claims of expertise made upon legal texts and claims made upon social knowledge, between a law school on one side of the windswept, difficult-to-cross divide, and the contextual scholars in the social science faculties on the other. But this is not the first time we have taken this path. Before text and context, there was a similar binary, law and society. The law and society dichotomy is deeply rooted in the kind of academic strategies legal historians employ. Moreover, it fits the neutral politics often inhabited by historians' noble dream of objectivity and a loyally distaste for dogmatism. When examining legal texts, historians can operate within the boundaries set by ordinary doctrinal analysis. The contextual approach represented by the law and society movement on the other side has a comfortable relationship to mid-20th century end of ideologies. As Michael Grossberg has argued, the Wisconsin School of Legal History, the practitioners of legal history grounded in the law and society movement, had a historically coherent view of law as a rational instrument that could be seized upon by members of the dominant middle class to achieve consensual economic goals. Its interest in private ordering, empirical social science, method, and functionalism often reflected a belief that social forces could be easily cabined into sensible categories. It's remarkable how long these hollow boxes, law and society, have remained with us. Frayed, rusty, somewhat dilapidated, this model continued to stand partly because of its usefulness in carving out a respectable role for legal historians, and partly because there was no sense of what might take its place. As Robert Gordon has pointed out, there always remains a conceptual problem for those who see the world as divided between two separate spheres, law and society, to work out the secret of that relationship. Secrets can be compelling. This paper focuses upon a different sort of relationship, the role of the legal historian as a reader of text. I emphatically, though, do not want to construct a read-a-text or a text-context dichotomy. Any discussion of legal historians interrogating text should not replace one shop-worn form of dualism with another. After all the binary paradigms, such as law and society or law in the books, law in action, why add another? It does not seem to matter what the source of these constructions is, whether liberal, Marxist, reconstructed Marxist, past and present school, identity-based critical studies, or simply passe. There is always some binary lurking in the background which can be plucked out of obscurity and turned into the legal, historical, methodological approach of the day. At a time when we've witnessed the crumbling of old binary distinctions that have defined scholarly thinking, should come as no surprise that dualism is not a terribly attractive distinction to make. So my goals are fairly modest. My essay seeks to identify the relationship of legal historians to text. How do we explain the fact that text is of essential importance to legal historians and at the same time under-examined? First, as I've mentioned, there is a gesture of strategic shifting back and forth between text and context, and never very thickly probing either category. The very prevalence of text, second, makes it less visible. Text is a precondition of legal historical study and is like water for fish, a milieu to be navigated rather than interrogated. Third, text is maddeningly an inexact construct. Derrida once famously declared, "Everything is text." It is an expressive container for holding ideas, a discrete set of symbols, a fluid, uncontainable part of a much larger fabric. In this sense, text is a social construction, an agreed upon subject. Fourth, text is the locus of interpretation. A text is what we call a text for the purpose of analysis. This might be an easy definition, a kind of textual positivism, but where does it take us? Like bespoke tailors, legal historians cut and reshape texts to fit their purposes. A text might be small, a statutory fragment or a rambling case, but there's always a decision being made about how to identify its size, boundaries, and contours. Fifth, the very mutability and silences of the text deny interpretation. The point is made by Walter Benjamin. The term text comes from the Latin word textum, meaning a woven cloth. It is woven as part of a much larger, more elusive pattern of remembrance and forgetting. According to Benjamin, the mother of text is Penelope. The day unravels what the night has woven. When we awake each morning, we hold in our hands, usually weakly and loosely, but a few fringes of the carpet. Legal historians are therefore as much the producers of text as the readers of text, but at the same time they're subject to its vagaries. So I seek to identify both the power of legal historians over text and the numerous ways they are subject to text's own demands. The relationship between legal historian and text, then, is not an easy hooking up, but a troubled, complex association that must be examined from the point of view of defining texts and which changes over time. My focus will be upon ourselves, the historians at work doing what they do best, providing temporality, rather than upon the text unmoored from time. Historians have a special gift of looking backwards. I will not offer any simple answers to the problems of texts. This essay is not a methodological guidebook, not a taxonomy of different sorts of methods of reading, not a celebration of the historian's métier, not a glimpse of the possibilities posed by borrowing tools from neighboring disciplines, not a historiographic essay, and not a manifesto, though it may slip into one or other of these genres from time to time. The essay is organized in 4 broad sections. This is the Ira-glass bit. The first section, what might be a legal text, probes the possibilities and difficulties inherent in defining a text. It addresses many of the problems we have identified. Immutability of text, its porous boundaries, its enigmatic nature, its self-contradictions. Must a text have an author? How should texts be read? Are legal texts different than other texts? Part 2, the strange career of legal textualism, asks why legal historians have failed to explore the technologies of textual interpretation. This is especially puzzling in light of mainstream historians' preoccupation with issues of methodology. In this section, I offer a brief excursus of the sociology of knowledge for legal history. The avoidance of theory, methodology, the heuristic term, is very much a part of how legal historians position themselves in the late 20th century legal academy. I trace some of the promising roads not taken. Act 3, a short dictionary of misunderstood legal historical terms, is based on Milan Kundera's insight that lexicons might be constructed around sites of contention. It examines a series of phrases which I hope might serve to open up the discussion of alternative historical methods. I choose to employ this sort of literary device because of my discomfort with either a straightforward and limited set of methodological approaches and with the polemical tone of many historiographic studies. The dictionary is intended to be illustrative of alternative approaches to writing legal history. Part 4, Blake's telescope, draws some tentative conclusions. So, Act 1, what might be a legal text? Just as Victorian women might experience bouts of neurasthenia, historians suffer from the close relative of a peculiar malady identified by Derrida, archive fever. What is archive fever? It is, to quote, to burn with a passion. It is never to rest interminably from searching for the archive, right where it slips away. It is to run after the archive, even if there is too much of it, right where something in it unarchives itself. It is to have compulsive, repetitive, and nostalgic desire for the archive, an irrepressible desire to return to the origin, a homesickness, a nostalgia for the return to the most archaic place of absolute commencement. The archive simultaneously preserves and hides the past. Is there such a disease as mal de texte, as Derrida described mal d'archive? Every text is a disappointment. It insufficiently informs. It lacks authority. It's incomplete. Text is chimerical, indeterminate, multivocal, slippery, generally untrustworthy. And what is not a text? Text has come to mean too much and too little. It is the object of study, but it also serves as the conditions of communication. The encounter between the legal historian and the text is fraught with danger. Texts often slip out of our hands. By the term mal, Derrida meant misfortune or disquiet as much as fever. Yet there is a kind of overheated pursuit particular to the historical calling. Mal de texte is a kind of occupational disease. Historians spend their lives in a quest looking for smoking gun texts, the writings of historical actors, which exquisitely reveal the blend of motive, guile, self-consciousness, which is not merely revealed by actions. This is what Michelet called the exhumation of their deepest desires. But texts, like lovers, rarely turn out to be everything we hope or imagine. Indeed, even if the text is illuminating, even confessional, it will expose its own lacunae. In some ways, knowing the etiology of this disease is helpful. It spares us slipping down the rabbit holes of heuristic thinking. We cannot master the slipperiness of our ever-elusive texts. We cannot flee our text for context. We cannot ever tie ourselves to the masts in order to be preserved from the sirens of multiple interpretations. Strikingly, we pretend that we have interpretive power. Our metaphors tell us a great deal about how we deal with texts in general, and all of them do not quite fit a legal text. Texts might be dissected, unpacked like a portmanteau, or become an ocular instrument as we search for optic. But Derrida points us in a different direction, where we look inwards toward the psyche of those searching for the past. In a sense, we are, in the delirium of our fevers, the creator and preserver of documents. A text is something we work upon, while a document is something we create. Roland Barthes, Jacques Derrida, Julia Kristeva have all pointed out that texts are multivocal, speaking to each other like crickets on a summer evening. The instability and chimerical character of texts is implicit to the text itself, because no text can ever be disentangled from others. If a text cannot be anything more than a crossroads of other texts, if the reader is critical for making the text unified by seeing, then, perhaps, we should turn to the reader, the legal historian, to speak of a relationship between reader and text, rather than of the text itself. Legal texts are different, and therefore they must be read differently. Brooke Thomas has pointed out, without a doubt, legal texts can have literary qualities, but in the last analysis, their function is different. Legal texts are often intentionally derivative, moving forward across time, established terms of art. They seek to be exclusive, limiting alternative interpretive challenges to authority, and making claims to being closely reasoned and inevitable in their conclusions. And above all, legal language is an instrument, a technology of power. It is impossible to read Robert Cover's Nomos and Narrative, which underscores the literary quality of legal texts, without the curative reminder of violence in the word, which tells us that behind every legal word lurks a threat. What makes an efficient legal text different? First, its authorial voice might be institutional, congressional history, for example, or legislative intent, rather than simply the voice of the single romantic author. The ventriloquist-like imposition of authorial intent upon the text is a cottage industry of sorts, legislative history, and therefore its artificial nature is more fully exposed. The text, second, is often a pastiche, a bricolage of terms from prior texts. Lawyers borrow shamelessly from each other. Indeed, the conservative use of language pushing words forward through time is a particularly notable aspect of lawyerly writing. Legal terms of art create well-traveled causeways between one text and another. But more importantly, the similarity of texts created by using boilerplate or conservatively retained legal language suggests that intertextual readings, that is, reading one text against another, must be an even more insistent task of the legal historian. Third, legal texts are always texts seeking to limit the reader. They privilege one reading over another as more authoritative, more correct. If all texts have some limiting function for meaning, then legal texts with their demands for interpretive exclusivity are particularly notable on the boundaries they place upon imaginative readings of alternative possibilities. Alternatives must always be justified. The art of distinguishing the case that allows one to read a judicial decision differently from another. This has been suggested for legal texts are instrumental texts. If, as Jackson Lears has written, all history is the history of longing, then all the interrogations of legal historical texts are forms of pleading. Act 2, the strange career of legal textualism. American legal history seems to have come of age. It is a multi-volume history of the country's leading judicial institution, the Holmes devised history of the Supreme Court. It has 2 massive encyclopedias published in the past few years. A new biographic dictionary identifies important figures. An older work, the Founders' Constitution, makes our constitutional canon to something truly canonical. The field has its own canonical works in both the areas of overarching narrative and a methodological critique, which can be emulated and serve as the foil for disagreement. In a certain fashion, legal history now embodies both the Enlightenment project, that is, encyclopedic surveys of knowledge, and the romantic, making and unmaking paradigms. In 1960, there were only 5 legal historians operating in elite law schools. Today, legal historians are considered an essential part of the infield of any major law school. Princeton's history department has its own distinguished chair in the field. Not surprisingly, legal historians are in a celebratory mood. As with any successful discipline, it is fragmented into schools, representing different approaches. Stanford and Wisconsin law schools reflect a long-standing law and society tradition. Virginia is doctrinal. Yale produces legal cultural history. Without a law school, Princeton has encouraged a particular focus on the role of the strategies of ordinary people within legal frameworks. Harvard, as always, is focused on whatever Harvard thinks is important. A professional organization hosts yearly conferences with devoted attendees who regularly travel to its meetings, and it even has the ultimate rite of passage, a website to trumpet our latest accomplishments. Still, I hesitate to join the huzzahs celebrating disciplinary triumphalism. Thick tones did not prevent 19th century Protestant theology from turning into an intellectual dinosaur. While legal historians often have claimed to be most comfortable with fellow historians, their connection has frayed as the larger historical academy has experienced new trends. The turn toward narrative makes historical study look remarkably non-analytic, the antithesis of the lawyerly focus on crisp intellectual maneuvering among texts. Identity history has placed gender, race, and class at the core of historical studies. The straitjacket of national jurisdictions has made legal historians seem fixed upon rigid national boundaries at the very moment that mainstream historians are probing the plasticity and the permeability of territories. When was the last time that a subaltern made a cameo appearance in an important legal historical monograph? If the new cultural history has often meant a history embodied, legal historians have been curiously disembodied. Legal historians, in other words, have been left behind by other historians. Legal historians are borrowers from borrowers. As intellectual magpies traveling from nest to nest, they occasionally bring methodologies borrowed from other areas of scholarship to bear upon their own legal historical inquiries. But when was the last time someone borrowed from us? We inherit derivative methodologies, remain uncritical of our own historiographic preconceptions. How many legal historians simply follow cases one after another like beads on a rosary until they reach a believable conclusion that this is the past? Much legal historical work is the head-note tradition, which in turn represents the slow accretion of legal doctrine. In some ways, while we claim the mantle of historians, the fact is that among historians, we are provincials. Moreover, as I suggested at the beginning, the tilt toward the historical academy rather than the legal has left us with the worst of both worlds. We're often insufficiently archival, poorly attuned to methodological concern. As the dealers in a particular kind of text, we're detached from other aspects of an historical period to be proper contextualists. The textual turn, I've argued, cannot provide an escape path, since it is simply the latest enunciation of a new historical methodology, each of which is ultimately proven to be a revolution, which did not happen. Or perhaps a better image might be a banana republic coup. The radio station is seized, a colonel in neatly pressed fatigues issues a statement about the failures of the old regime, offers overstated promises about what will come in its place. It is all very dramatic. In the end, however, the change in regime also fails. These are all reasons to rethink our identity. All the faux theory in the world will not make us real historians. Nevertheless, as I will argue, we've retreated from the normative task of lawyers, and I believe this is the side of identity which offers the most promising possibilities. But our law academic legacy also has its limits. It is striking that there are almost no autobiographies of law professors. The legal profession, and especially the legal academy, with its focus on performative pedagogy, does not favor the cultivation of internality. Even when lawyers were influenced by reading ancient classics, they gravitated to Ciceronian rhetoric rather than stoic self-examination. In contrast, numerous fine memoirs of historians have been written. Historians are inclined to this genre for a variety of reasons: to create a document for a future generation of historians, to situate their themes within the larger intellectual and political currents of their times, to apprentice the next generation of scholars through the telling of a Bildungsroman, the How I Became a Historian genre. Nevertheless, what is striking is that the degree of self-regarding, inner consciousness, awareness, attunement to psychological postures, knowing the deeper aspects of the personality, all this seems notably lacking among lawyers. Legal historians seem to share this outer directedness. What might remedy the situation? Short of encouraging Freudian psychoanalysis or mandatory training in spiritual exercises, it's unclear how to promote the transformation of the legal historical psyche. Yet without such a change, the reading of texts in a truly sophisticated way remains out of reach. Legal history developed in this particular fashion largely because of not taking certain roads. There were two particularly promising approaches that were missed: historical jurisprudence at the end of the 19th century and the historical contribution to legal realism in the 1920s and 1930s. The first of these, historical jurisprudence, argued that the contingent, evolutionary, and unmasking of past forms might have a critical influence on how we think about making law in our own times. Maitland brought a sense of the longue durée and a willingness to ask enduring questions about the origins of liberty and the nature of equality. He embraced rather than fled emerging debates in political theory. Vinogradov brought to historical jurisprudence a cosmopolitan note. He divided the world into historical jurisprudence, into the rationalists, nationalists, and evolutionists. And like Maitland, he brought into the discussion psychology, empirical investigations, and a sense of rootedness and its influences on historical process. Historical jurisprudence was an alchemical movement, turning the experience of history into the logic of law. Unlike the Rawlsian dance of the seven veils, it does not strip human beings of their culture and past. It creates a radically situated subject. Then, during the 1920s, Julius Goebel's class in Columbia, Development of Legal Institutions, also constituted an attempt to situate legal texts in their contexts. The course was intended as a means of repudiating the tradition which confined legal historical inquiry to a mere genealogy of cases. It focused on the role of social sciences, political, economic, or social factors, and the growth of particular rules or institutions. Goebel saw law not as an isolated phenomenon, but as a phase of civilization. There was a real possibility of constructing a legal history for the age of legal realism. Goebel's casebook began with the murky origins of curvature, but it ended with the New York Married Women's Property Act. Law students should learn is flexible, contingent, and liable to change with circumstance. The paternalism of common law notions of control over the property of wives was the casebook's endpoint. If historical jurisprudence lost to analytic philosophy and deontological liberalism, then the historicism of realism might be said to have been the victim of an empirical realist turn. The irrelevance of history became a legacy of realism. Precedent provided a dead weight from the past that created burdens for the recasting of a modern, outcome-driven legal system. As legal realism abandoned history for the two-dimensional temptress of law and economics, legal historians turned inward. Yet Goebbels often seemed to portray common law as our Roman law, filled with obscure doctrinal adherence to traditional common law doctrine. He demonstrated a penchant for creating a common law as dense, full of obscure terms of art and dry as dust interpretations of the specifically English past in an ever more global world. Act 3, a short dictionary of misunderstood legal historical terms. In The Unbearable Likeness of Being, Czech novelist Milan Kundera includes a short dictionary of misunderstood words. These are words seemingly shared, but in fact subject to multiple, often conflicting meanings by a romantic couple, Sabina and Franz. Women betrayal, living in truth, parades, light and darkness. According to Kundera, there is the semantic susurrus of the river flowing through this language. An intimate vocabulary captures the connection between them. For our purposes, I'll try to define a few phrases that might guide the relationship of legal historians to texts. The counter-genealogical gesture, palimpsest legalism, legal history of the imagination, and thin normativity, thick normativity. First, the counter-genealogical gesture. What does it mean to operate in a counter-genealogical fashion? It means to search for alternative paths and roads not taken, elective affinities that do not seem to be obvious connections. Yet somehow historians have ended up tracing the origins of contemporary legal doctrine or institutions in a comfortable, linear fashion. For example, uncovering the intellectual pedigree of federalism, or the early modern structure of appellate institutions. This is not a new role. Law was traditionally the keeper of both official codes and official pasts. In the Greek polis, public documents are kept in the archaion, which was often the home of the magistrate. Continuity, however, tends to replicate what Bentham calls the everything as it should be form of legalism and renders legal history the least dangerous branch of legal science. Law does not replicate itself naturally with one rule begetting another in biblical style. Instead, laws have resonance which can reverberate through time by being seized upon by others mining the past. Anti-abortion activists have seized upon the resistance of northern 19th century Americans to the Fugitive Slave Acts, which made immoral demands for the capture of slaves in free states and the return to their masters. Anti-gay marriage proponents have mined the anti-polygamy movement of a century earlier. These are examples, of course, of the Nachleben, the afterlife of statutes, an afterlife which only comes into existence because later generations have identified threads of real or even make-believe connections. The section is incomplete at this point. Stephen intended to go on to discuss how Benjamin's distinction between genealogies on the one hand and elective affinities on the other might inform a non-genealogical legal history. Second, palimpsest legalism. To borrow a psychoanalytic term, which in turn borrowed from art history, if you peel off one layer of history on a canvas, another might be discovered underneath. And in this section, Stephen intended to discuss the methods which might be used to strip away one past to see another. Third, the legal history of the imagination. Often by definition, a legal text is a text because it's official, created by the arbiters of legal authority, legislators and councils, judicial figures, monarchs, and constitutional conventions. This is a kind of Austinian positivism adopted by legal historians. As Austin defined law, it is a rule set by men, a command of a superior to an inferior with sanctions for non-compliance, that is, a bark with a bite. The purpose of such a definition is to provide a description of what law excludes as a category. Law emphatically was not custom, natural law, divine and normative interventions, or the embodiment of justice in rules. Law was seen as a hegemonic power of the state. But in fact, a great deal of law has been made outside of official legal boundaries. Imaginary punishments, mock executions, parodic statutes, stillborn reform proposals, fabular narratives about how law came into being. Law is often envisioned, formulated, represented as a cultural artifact by a wide array of historical actors, including the common people, independent of government's power to command and punish. This might be called the legal history of the imagination. Law might be made out of myth. Indeed, legal historians must free themselves from the shackles of a kind of historical positivism. Rankes, wie es eigentlich gewesen ist, that is, as it actually was, as well as legal positivism. French medievalist Alain Barrault, for example, shows how one of the best known laws of the Middle Ages, the jus primus noctis, the right of the feudal law to have sexual relations with the bride of a vassal on her wedding night, was in fact an exceedingly well circulated myth. Robert Tsai is currently working on a project identifying a collection of constitutions, America's forgotten constitutions, those written by citizens as diverse as 19th century utopians, to John Brown's followers, to 20th century white supremacists. Elsewhere, I have shown how Jewish legal commentators constructed an entire alternative universe of pre-Sinai law in order to pose the jurisprudential possibility of a legalism more oral, more customary, more discretionary, and more concerned with the psychological question of how a norm-bearing person might be created outside of the blunt obligations imposed by a divine law-giving moment. Even more intriguingly, imaginary law might be used to construct overarching narratives that might replace our traditional stories about legal origins. Take the classical question of the beginnings of British North America's legal and constitutional order. The received tradition is one of settlement, grants of authority from the Crown, the establishment of legal institutions such as courts and legislatures. Such a narrative hands down legal authority in the fashion of an apostolic succession. The monarch and his chartered agents, Parliament and its courts, are repositories of the legalities of early America. These ultimately will be transfigured in the final succession to a new constitutional order. Yet among the earliest legal codes of post-encounter New World were those written by buccaneers and utopians. Pirates established direct democracies with equal voting and equal shares in booting. What does it mean that New World constitutionalism might have its origins between the devil and the deep blue sea? Or perhaps America's legal tradition began in the aspirations of Europe. Before actual legal structures were created, they were imagined. For some, like Thomas More, the New World is a place where all things grew milder, the air less burning, the soil more verdant, the beasts less wild. In such an environment, it might be possible to experiment with new forms of governance. Lastly, thin normativity and thick normativity. Thin normativity is the usual kind practiced in the rarefied atmosphere of law reviews. Change the following provision to provide for a different outcome. Thick normativity is the shifting of lenses. What happens to the way contract doctrine might be constructed if an historian unearths evidence of equitable consideration in an earlier period? What does it mean for contemporary law if the public-private distinction only emerges in the present-day form late in the 19th century? How important is the fact that transparency was a central feature of late criminal punishment of the period of the American Revolution? Thick normativity then identifies the role of a legal historian to reorient the viewer. And finally, conclusion, Blake's telescope. According to William Blake, the problem with the telescope is it alters the ratio of organs but leaves the object untouched. Legal history shares this optic, filling and reorganizing text in neat narrative categories, sometimes describing continuities and other times focusing upon rupture. Legal historians magnify the macrocosm of legal documents. They chart the constellations of how the documents are related to change. When the documents do not fit together, they readily adopt epicycles. However, legal historians less commonly are willing to dissect texts, plumb their multiple meanings, and in a sense, doing violence to the text, operate on them to reassemble legal expression in order to show their inherent possible meanings. The butter knife, not the scalpel, has been their favorite instrument. They often shy away from the essential task of lawyers, close reading and seeking social change, and remain coiled up in their comfortable academic niches. As scholars, legal historians have proved more at ease with a distant vision than with tangible normative proposals. The object has too often remained untouched. Since this essay has sung the praises of thick normativity, let me conclude with a normative, or at least a prescriptive summation. I've tried to strike a path midway between two frequently taken roads in discussions about historians and their work, and to apply these to the ways we might think about the future of legal history. On one hand, we should be more self-conscious about methodology than merely reasserting the centrality of craft. Of course, there's the historian's Boy Scout code of honor. We must be careful with sources, diligent in pursuing facts, recognize the contributions of others, hold a finely attuned intuitive sense of the political and social culture of a period, cultivate felicitous rhetoric, and always keep in mind the mantra of change over time. But métier should not mean that we embrace avowed theoretical impoverishment. On the other hand, we cannot turn into the young and the restless, a sort of James Dean academic discipline, always cruising down the road in search of the next big methodological approach. After the social historical term came the cultural anthropological term, then came the linguistic term, finally the global term, which took the road into the borderlands, past subalterns, and across boundaries. After all these terms, is it any wonder that we are experiencing a sense of intellectual vertigo? No doubt some legal historians will keep waiting for the next big paradigm. While those seeking a new paradigm might consult Gordon's pocket guide to the exotic varieties of legal historical approaches, an even greater temptation is to reach for a do-it-yourself methodological toolkit. Rummaging about for methodologies, however, is no more satisfying than the search for an off-the-rack suit without any sort of measurement whatsoever. Galileo's observatory tower in Padua looks remarkably like the turret of a Renaissance palazzo, reaching into the sky. It has all the hubris of the fortified home of a Florentine or Venetian patrician. The soaring height, the square observation point, sitting aloft a narrow red brick turret, and the decorative carving of the buttresses. All this bespeaks a raw assertion of power. If a Renaissance artist wished to depict the Tower of Babel, he or she need not proceed any further. Imagine, though, this structure in Galileo's own time. Within this battlement stands a figure, squinting through a small brass telescope. The lenses are scratched, the length of the brass tube extends barely an arm's length into the heavens, and the object remains untouched. His text is the arrangement of the stars on the evening's dusky canvas. Has he forced the heavens to yield another one of its secrets? But Galileo has come to recognize a more important truth. Observation is simply the beginning of heresy.
So my paper will seem, in fact, painfully simple after that. But I'll just proceed anyway. So two related questions animate my paper, which the first is, how is it that the common law tradition remained such an integral mode of governance in the United States from the American Revolution until the early 20th century? And second, what does the flourishing of the common law tradition in America through this period tell us about the relationship between law and history, and how might that relationship illuminate some of the questions raised by this conference as I understand them? So, at first blush, the vital presence of the common law might seem odd in a country that was premised in so many ways in breaking with its European past and an assuming political control of its own destiny. After all, the common law had originated in and remained closely identified with England. It was ideologically committed to upholding precedent and to repeating the past, claiming as it did so to embody the immemorial customs of the English, customs so old that their origin lay beyond the memory of man. It consisted of judicial rather than legislative articulation of legal principles. This was because only common law judges, according to the story, were deemed possessed of what they called the artificial reason necessary to shape it. For all these reasons, one might expect Americans, who were intensely proud of their Republican experiment, to reject the common law. Instead, throughout this period, it was widely, although never universally, claimed and celebrated. In no small part, this was because the common law came with such heavy ideological freight. Since the early 17th century, English common lawyers had resisted the encroachments of the Stuart monarchs in the name of England's ancient constitution and agglomeration of immemorial, endlessly repeated common law freedoms. As a result, many prominent American legal thinkers from the 18th century on considered the US Constitution to be informed by and indeed to be incomprehensible without reference to the common law. Combined with this storied history of resisting the claims of monarchs, the common law's claim to represent the immemorial customs of the community made it possible to argue that it was entirely organic, emerging from the people themselves rather than through any imposition from above. From the perspective of its adherents, this made the common law the most free, the most self-given of all possible laws, a crucial component of American freedom, and indispensable supplement to American political democracy. It was little wonder then that 19th century American lawyers would argue that the common law was more than merely important in America. America was unimaginable without it. Now, as legal and intellectual historians writing today, we are apt to think of the survival of the common law in America through the 19th century in at least two different registers, but you could come up with others, of course. First, and less important for my purposes, one might think of it in terms of the relative weakness of the American state throughout the 19th century. America was, of course, famously a country of courts and parties rather than of a state. Right? A state, and there's of course been predictable historiography complicating that claim, but that's okay. Right? A state that could generate law was missing, judges filled the gap. Second, and more important for my purposes, we might think of it in terms of the triumph of a certain conservative ideology. The 19th century common law and the judges who administered it are often seen as premised as standing for strong property and contract rights and against the redistributive impulses associated with social democracy. Viewed as an instantiation of a conservative ideology, the survival of the common law throughout the 19th century might be explained in terms of the impoverishment of American social democracy until the early 20th century. Law is politics, of course, as we all know, and the grip of an anti-redistributive common law judiciary and the common law in general then can be explained as the reign of a conservative politics. I argue in the longer paper that when we see law as politics today, we are heirs to a particular modernist way of thinking about the relationship between law and politics that ultimately rests upon a certain understanding of history. Right? This understanding of history emerged in the late 19th century and is most clearly revealed in the writings of Oliver Wendell Holmes, although Holmes is by no means alone. For Holmes, thinking historically was ultimately an anti-metaphysical strategy. Right? By thinking historically, one demolished the atemporal metaphysical foundations upon which law, or in fact any other foundational philosophy, rested. Once law's foundations were undermined in the name of history, there was nothing separating law from politics. As such, common law judges enjoyed no monopoly on lawmaking. Indeed, common law judges' activity came to be seen as illegitimate, as encroaching upon the turf of democratic majorities. Under the impact of the Holmesian revolution and legal thought that followed in the early 20th century, the common law declined in prestige and retreated as a mode of governance, at least relatively speaking. Law in the 20th century, as we all know, was taken away in important respects from common law judges and turned over to democratic majorities. The relative demise of the common law was the relative triumph of democracy. This is, of course, a familiar enough story, although it is not often related in terms of the emergence of a certain anti-metaphysical historical consciousness. My object, however, is to attempt to make sense of the longevity of the common law in 19th century America by examining the very different relationships among law, history, and political democracy before the Holmesian revolution in American legal thought. This inquiry might enable us to think differently about how law and history have worked together. In order to begin to examine the relationships among law, history, and democracy in 19th century America, one has to distance oneself from one of the critical assumptions of modernist historical thought, namely that an iconoclastic dismantling of the metaphysical foundations of phenomena through the technique of revealing their temporal origins will clear ground, enable critical self-reflection, and open up the world for reimagining and remaking. This was not the ideational world of 19th century Americans. Indeed, the 19th century was a world in which the notion of given constraints was very real indeed. One standard explanation for the persistence of the givenness of constraints is that even though Americans had long ceased to enact biblical strictures as law, this was a society that remained overwhelmingly religious. But the presence of religion in 19th century American thought, if offered up as a definitive explanation for the givenness of constraints or limits, is simply too broad. Right? It tells us nothing about the complex ways in which 19th century Americans went about constructing their worlds and naming limits. So in what follows, I begin by offering a sense of how 19th century Americans imagined the scope of political democracy, the formal sphere of the political. The formal sphere of the political, which would be called upon to do so much heavy lifting in 20th century America, was often imagined as constrained, but it is the kinds of limits that were imagined, and the ways in which those limits were made to interact with each other that are ultimately of interest. When it comes to 19th century understandings of political democracy, it's important to keep in mind a cardinal fact that we ignore to our peril. From the American Revolution into the 20th century, throughout the Western world, political democracy, even as it was an aspiration for millions, was new and exceptional and not necessarily viewed as a prerequisite to national prosperity or prominence. the explosive eruptions and vicissitudes of various revolutions, the late 18th century revolutions, the Latin American struggles, the revolutions of 1848, the Paris Commune, to name just a few, underscored political democracy's instability, unpredictability, violence, and dangerousness. It should not be surprising then that political democracy was the object of deep, ongoing suspicion. This suspicion was at the heart of the Republican tradition that gave rise to the elaborate structures of checks and balances in the US Constitution, as we all know, but it continued into the 19th century long after the preoccupation with republicanism had waned. Thinkers strove mightily to ponder political democracy's limits, to conjure truths that the democratic subject, in his arrogant assertion that he could remake the world through self-conscious political activity, would be unable to tamper with. The mid-century Scottish romantic, conservative historical thinker Thomas Carlyle offered the catchiest formulation, one that enjoyed considerable currency throughout the English-speaking world. Carlyle analogized the nation to a ship that had to round Cape Horn. Right? Was the establishment of political democracy among the crew of the ship sufficient to negotiate this confrontation with an inexorable and limiting nature? Carlyle's answer was unequivocal, and I'm quoting Carlyle now. Quote, "Your ship cannot double Cape Horn by its excellent plan of voting. Right? The ship may vote this and that, above decks and below, in the most harmoniously exquisite constitutional manner. The ship, to get around Cape Horn, will find a set of conditions already voted for and fixed with adamantine rigor by the ancient elemental powers who are entirely careless of how you vote." Right? Ships, accordingly, do not use the ballot box at all. One wishes much some other entities, since all entities lie under the same rigorous set of laws, could be brought to show as much wisdom and sense, at least of self-preservation, the first command of nature. Democracy is a very extraordinary method of navigating, whether in the Straits of Magellan or the undiscovered sea of time. Right? So nature, or ancient elemental powers in Carlyle's formulation, consisted of a, quote, set of conditions already voted for and fixed with adamantine rigor that operated at its absolute limits on political democracy. But one should not imagine that the world of the 19th century was one in which limits to political democracy were necessarily self-conjured up only by those ideologically opposed to it, such as Carlyle. What we take to be a limiting or cabining of political democracy was in fact often merely taken to be an actually existing feature of political democracy, nothing other than the order of things itself. Throughout the 19th century, American political and legal thinkers were acutely aware of political democracy's manifest and most necessary or inevitable incompleteness, even in those very few countries that claimed to be democracies. 19th century American political legal thinkers were fully aware, for example, that large segments of the Native American population, a changing group that included women, minors, African Americans, Native Americans, propertyless white males, were not full participants in the polity, but were nevertheless subject to its laws. At the same time, they were conscious of how much of the rest of the world was non-self-governing. Right? While some saw this as the basis for demanding an extension of political democracy, others did not see that this incompletion made American political democracy less democratic, but instead that it underscored the fundamentally or essentially non-democratic nature of law. Right? This in turn fed the sense of constraints on political democracy, a Burkean inevitability of subjection to a governing order that one had not chosen. Did the fact that women were constrained to obey laws that they had not had any part in making itself not imply that everyone was similarly constrained? Right? And you see this, in fact, in the writings of someone like Joseph Story. Right? So this sense that the world was in crucial ways beyond the power of the democratic subject to remake imbues 19th century American political and legal discourses. It allowed political democracy to coexist with various kinds of limits, most of which we would today reject as being founded on an illegitimate metaphysics. As a result, the political legal sphere was crowded with metaphysical times, ahistorical and historical, times with mysterious origins, times with a given logic and direction and meaning. For our purposes, the two different kinds of given times that enjoy currency as limits to the sphere of political democracy are the non-historical pre-modern times of the common law on the one hand, and the changing times of metaphysical history on the other. The ways in which these times intersected, I suggest, should lead us to, quote, provincialize, and here I'm referring, of course, to Dipesh Chakrabarty's book on the subject. My friend Ritu Birla, of course, has said that mine is a very Indian book about America in some ways. So I should lead us to provincialize our own post-Holmesian thought, to render its reign less tyrannical and belittling as we look back on the 19th century. So let me first begin with the non-historical time of the common law. From the 17th century on, the common law tradition had claimed for itself the self-consciously non-historical time of immemoriality. The origins of the common law was said to reach back to a time beyond the memory of man, a time beyond historical specification or determination. It was precisely this resistance to history that common lawyers relied upon to claim legitimacy for the common law. Freed from the strictures of a law that could be pinned down in chronological time, common lawyers could claim a diffuse, imprecise, and mysterious antiquity on behalf of the common law. This special antiquity allowed them to claim superiority vis-à-vis law-giving acts that could be located in chronological time, such as acts of monarchs or legislatures. Right? Such temporally delimited acts of monarchs, common lawyers argued, could never possess the wisdom of a law that embodied the wisdom of multiple generations going back into the mists of time. But the immemoriality of the common law did not mean that it was immune to change. Even as they maintained that the common law was, quote, immemorial, 17th century common lawyers hailed the common law's ability to respond to changing circumstances through recourse to what I call the time of, quote, insensibility. The common law changed so insensibly, it was argued, that it could never be seen to change. Right? This was, in other words, also a time impervious to historical specification or determination. The precise moment of change could never be pinned down in chronological time. Change could only be inferred by comparing origin and endpoints. Right? And once again, common lawyers used this time of insensibility as proof of the common law's superiority because it was, quote, insensible. Whatever change the common law brought about was less abrupt, less disruptive, and less violent, they argued, than the sudden changes introduced by monarchs and legislatures. It was precisely the indistinctness of these times of immemoriality and insensibility, times that could and would easily crumble under the magnifying glass of modernist historical thought, that American lawyers claimed, albeit in complicated ways, throughout the 19th century. To 19th century American common law thinkers, the Benthamite charge that common law judges made law as they pleased was simply an illegitimate aspersion. To them, the common law was an inherited body of immemorial doctrine that commanded a measure of fidelity, but this was never a blind fidelity. Above all, the common law was a method. Indeed, the best, the most scientific, and the least despotic method of, quote, insensible step-by-step lawmaking. The common law judge was uniquely privileged, far more so than any elected legislature, to, quote, read the community that presented itself to him in the courtroom. When the common law judge spoke, in other words, the common law corresponded perfectly to the actually existing state of the community. He decided case by case, unwilling to turn his back on the past or to plunge headlong into the future. As such, the common law judge was committed to a careful calibration of the competing claims of the past, the present, and the future, of maintaining the identity of society of the time, even as he was committed to change. Right? The authority of the common law came precisely from its indistinct temporalities. So when these features of the common law method were combined, it was democratically elected legislatures rather than common law judges that appeared to produce law in moments of wild abandon, devoid of any connection to the past, correspondence to the present, and solicitude for the future. It was legislatures that were unscientific in their lawmaking. American political democracy shared space, as it were then, with a law that began but could not be seen to have begun, that changed but could not be caught in the act of changing. Right? The indistinctness of these times of the common law assured fixity and flexibility all at once. The second kind of metaphysical time that limited the scope of democracy in 19th century America was the time, or rather I should say the times, of metaphysical history. Throughout much of the 19th century, history was not self-consciously anti-metaphysical. When one contemplated the historical world, one did not see it, as many historians are now accustomed to seeing it, as the product of nothing but history, as one historically located phenomenon giving way to another. One saw it instead in terms of the logic of a number of metaphysical firsts, right, that underlay the passage of time and that gave it meaning. So these metaphysical firsts went by various names: God, spirit, laws, life, and so on. There has been a powerful tradition in American intellectual history that has charged American historical thought with inadequacy or weakness. 18th and 19th century Americans were too mired in their sense of their own exceptionalism, we have been told, to understand their historical world as genuinely historical, i.e. as devoid of a foreordained directionality. Regardless of the overwhelmingly metaphysical nature of 19th century history, discussions about history and about America's place in history were vigorous, a fact that intellectual historians often slight. Even though 19th century Americans organized the historical world in terms of a number of metaphysical firsts, they did not necessarily agree with one another about what constituted the logic of history. There were many different accounts of what history was about, of where it was headed. Furthermore, for all Americans, the actually existing world was unambiguously complex, crowded not only with different logics, but also with what had come to be recognized as exceptions to those logics. Metaphysically written ideas of history were applied to American democracy from the American Revolution going forward. Even as many in the 19th century saw democracy as itself furnishing the logic of history, to the extent that history was imagined to possess an underlying logic, it could equally serve as a check on democracy. If history had a meaning and was going somewhere, in other words, it was possible to judge the activities of a democratically elected legislature in terms of that logic. Thus judged, the legislature could be wrong in the sense that it was guilty of flouting the logic of history. Let us take the example of slavery. Pro-slavery thinkers in the mid-19th century believed that history instantiated the natural law of subordination of blacks to whites, right? And history proved this natural law. One could look at the subordination of blacks to whites across temporal and geographic contexts and conclude this. But it also implied that American democracy could not violate this natural law. Anti-slavery legislation was thus represented as an exception to this law, as something that went against the logic of history itself. Right? So the space of democracy was cabined, or limited in other words, by the logic imagined to imbue history. So thus far I've been arguing political democracy in 19th century America coexisted with two different metaphysical times, that of the common law on the one hand and that of history on the other. It is in the intersection of these times that we see how common law is made out a case for the centrality of the common law as an important mode of governance in America. Now, I'm not suggesting, to be sure, that the common law as a mode of governance, that the flourishing of the common law in the 19th century is entirely due to 19th century common law's skillful mobilization of the times of metaphysical history, so that would be a certain kind of crude idealist argument that would be as bad as the crude materialist one. Nevertheless, 19th century lawyers' turn to history remains noteworthy. It reveals their thinking to be far more sophisticated than we've given them credit for the most part. It goes at least some way towards explaining the resilience of the common law in the 19th century, and it serves to diminish Holmesian thought's monopoly on historical thinking about law. Armed then with the indistinct common law times of immemoriality and insensibility, convinced of the superiority of the common law method over that of legislatively generated law, 19th century American legal thinkers turned to the common law tradition to make sense of pressing issues ranging from labor to crime, commerce to slavery, marriage to local government. Thanks to the work of Morton Horwitz and others, we've long known of the considerable creativity of 19th century American lawyers in shaping legal doctrine to suit the needs of America's emerging market economy. However, it is important to emphasize that the common law was by no means the exclusive preserve of pro-commerce legal conservatives, although it was often that. In the slavery debates, for example, common law ideas sustained both anti- and pro-slavery positions. Right? During the years of the Civil War, when Americans had to rethink the very nature of their political system, the common law tradition could even provide a legal framework for the prosecution of the war. Indeed, we need to think of the common law tradition as being a tradition of thought in and of itself, encompassing ideas about time, law, society, and government to which American legal thinkers turned again and again. Even as they turned to the common law tradition, however, 19th century common lawyers turned to the very metaphysical times of history. The ubiquity of historical thought of 19th century common law thinkers compels us to be more cautious in talking about the uniqueness of the modernist turn to history. History, as I suggest, was something that common law thinkers were doing all along. Indeed, it was a virtual obsession. If we think of 19th century common law thought as crudely instrumentalist or formalist or repetitious, we're operating with a caricature of the way this important body of legal thought worked. In the first instance, the bringing together of the metaphysical times of the common law and history served to subject the common law to history. From the 18th century on, English and Scottish legal thinkers were acutely aware that the old common law had developed in a land-based feudal society. Their challenge was to fit it to the needs of a commercial society. American lawyers were similarly aware that the English common law did not fit the needs of their country in many respects, and that changing circumstances would require that it be revisited. But from what perspective was the common law's inconsistency with the condition of America to be judged? History, understood as something imbuing time with meaning and logic, would provide the necessary perspective. From the time of the American Revolution going forwards then, American common lawyers judged the common law rigorously in terms of the varying prevailing logics of history. Thus judged, parts of the common law were declared obsolete and excised, others systematized, yet others reformed or revived. American common lawyers' critical use of metaphysical history tells us something significant, I think, about the relationship between metaphysical and anti-metaphysical history. From our post-Holmesian perspective, it is anti-metaphysical modernist history that allows us to see bits of law as contingent and therefore as subject to reform. But 19th century common law thinkers were also able to render bits of law contingent and therefore subject to reform. The only difference is that they saw it from the perspective of a history that was metaphysical, that had a meaning, logic, and direction. Religious faith is so little at variance with skepticism, the philosopher Carl Löwit, who was a student of Heidegger, observed half a century ago, quote, that both are rather united by their common opposition to the presuppositions of a settled knowledge. If I understand the statement correctly, Lowith is arguing that religious faith, which might be a stand-in for the metaphysical histories of the 19th century, and skepticism, which might be a stand-in for the modernist anti-metaphysical histories following Holmes, are both opposed to settled knowledge. Both are techniques for unsettling knowledge, for seeing things as contingent and therefore as changeable. In being brought to bear on the common law, the metaphysical histories of the 19th century then were no less effective than their 20th century counterparts. Even as they subjected the common law to history, however, 19th century common law thinkers could argue that the common law, occasionally as doctrine but more often as method, itself realized and embodied the logic and meaning of history. It's important here to emphasize that because 19th century common lawyers were not using history to pull down foundations generally in the manner of Holmes, the common law was never dissolved into history and therefore reduced to politics. The times of the common law and history brushed up against each other, informed each other, constituted each other without destroying one another. History produced a perspective on the common law, but at the same time the common law produced a perspective on history. 19th century common lawyers then revealed themselves to be able to simultaneously to inhabit two different types of metaphysical time, right? The non-modern times of the common law on the one hand, and the varying times of 19th century history on the other. Understanding common law thought in 19th century America as a shuttling between the time of law and the time of history, as a subjection of the common law to history, and as a subjection of history to the common law, goes some way, although of course not all the way, towards explaining the extraordinary resilience of the tradition of common law thought in 19th century America. The common law tradition the common lawyers drew upon and defended so vigorously throughout the 19th century could not have survived the way it did had it not been constantly updated, constantly reinvigorated, constantly represented in terms of the historical consciousness of the period. At the same time, and just as important, arguing that the common law itself embodied the logic and meaning of history secured a place for the common law in America. Political democracy in America was incomplete, crowded with given times constrained by history. When the common law was joined to history then, common lawyers were able to argue that they, rather than democratically elected legislatures, were better able to take American society in the direction in which history was pointing, better able to embody history's meaning and logic. When history ceased to have a necessary direction, as was the case when a modernist anti-metaphysical history emerged around 1900, the common law could be made to look like mere politics, right? By its influential opponents. Until then, common law thinkers could argue that they had a vital role to play in America's development. And this is, of course, a totally overdetermined and exaggerated conclusion, because I think the history of the 20th century is much more complicated than the one I've just presented to you, but that's not something I deal with a lot. What 19th century common law thinkers' use of history does, I suggest, is it offers us then to return then to the imperatives of this conference, right, which we all feel somehow compelled to produce a relationship to. What 19th century common law thinkers' use of history does then, I suggest, is offer us one mode of thinking of law as history. In bringing history to bear upon the common law, which is what law and history scholarship attempts to do, 19th century American common law thinkers simultaneously argue vigorously that the common law itself embodied or realized the logic of history, which would be one way of arguing law as history. Right? So if we take 19th century legal and historical thought seriously, we might find in an impossible combination of history and law, a way of thinking law as and law and both at the same time. Right? The challenge posed by this conference, in other words, is something that 19th century American common law thinkers were doing all along. Right? But to show that something was done all along, right, does not, nor is it intended to, diminish the innovative nature of the question as it has been posed to us here. So, yeah, that.
Good morning. I want to add thanks to Chris and to everyone at Irvine for the invitation, and what in particular I know for Chris must have been countless hours bringing everything together. Catherine sort of said what I was going to say, which is that he's the kind of colleague that makes all of us wish we could replicate him or multiply him at our own institutions. I won't name names about who I want to be replaced by that replication. So let me just say that he's the kind of person and scholar that makes you grateful and happy to be an academic, full stop. I'm not going to read from my paper for a variety of reasons that would cause me to have to talk with my therapist. And indeed, I must say I'm tempted just to take Stephen's dare and summarize my paper by saying that I do indeed favor analysis for legal historians and lawyers alike. The paper is also fairly brief, and it's now lodged in cyberspace, I guess with my consent, notwithstanding rather considerable ambivalence on my part about its current structure, style, content, so there's dissemination enough of the text. And I guess I'm not going to tell you how many times and how many different ways I tried not to write the paper in its current form. I will say that I began writing to say something very different, with the purpose of trying to say something very different about resistance. I had possibly metaphysical ambition to ground resistance in something outside itself, something that would provide means for connecting, in particular, resistance to justice. Something along the lines of a connection that Stuart Hampshire explores in a lovely argument in his provocative book, Justice is Conflict. That project failed repeatedly. So I stopped digging, and the paper is essentially what's left of the abandoned pit. I'm not completely devastated by the failure, though the reasons for that may give you some pause. Marion may accuse me of silencing justice, but I must say that the paper and the larger project of which it's a part that I want to speak to, that will involve speaking some law in some cases, in it I have been drawn away from justice to questions that seem to circulate in and through again and again. Indeed, to be constituted by, and that's the point I want to try to make now, in and through, to circulate in and through, and indeed to be constituted by resistance. So to get at that, consider, if you'll pardon the conceit, the consequences of inverting or, frankly, bastardizing the famous natural law expression, an unjust law is no law at all, and inverting it with resistance, to produce something like the form, a law without resistance is no law at all. Now, in descriptive terms, the latter is surely more accurate. Positivists have been rather officiously, and I think too long, insisting on the point that we cannot use any measure of justice to identify what counts as law. And perhaps I could convince some natural law theorists, if there are any of you out there, to concede that it's really your resistance to law, in the name of justice to be sure, but your resistance that redeems even if it does not define the status of law. The richer implications of the inversion, a law without resistance is no law at all, are not descriptive in this sense, in the sense that's occupied a tremendous amount of legal theory. They spring instead from what I take to be the more basic point, one that may strike you, I hope strikes you as obvious, the more basic point that law marks without ever eliminating the areas of dispute, of social conflict. Undisputed terrain, wherever it may be found, I'm dubious, does not typically require the articulation of an enforcement of law. It's not when we need law. I think this is as true of Marx's laws of economic determinism and the mechanics of censorship and psychoanalytic theory as it is of formal law. But here, for now, today, staying with formal law, consider the following. Civil liberties are written against government temptations they cannot eliminate. So they mark a point of resistance between citizen and state. Indeed, in some of the most important instances, the government interest that leads to infringement, or what we want to call infringement of civil liberties, is not some illicit temptation, but an expression of constitutional duty itself. So we have conflict between fundamental legal commitments, not a simple narrative of infringements, though we're always wanting to tell the narrative of infringements. The tension between the Fourth Amendment and police investigation comes to mind, comes to the courts quite frequently. The fact that both legal values in the Fourth Amendment and the duty to faithfully execute the laws, which all executive officials swear to, can be framed in the language of justice seems to me, in the pit, less significant from an interpretive standpoint than the simple fact that both take their meanings, both values take their meanings as law within a structure of irreducible resistance. The classic example, or one that I'm going to call classic for my purposes, 1928 case of Olmsted versus United States involving the use by the Department of Justice attorneys of evidence that had been obtained knowingly by illegal wiretaps in order to secure convictions. The case is famous, you've probably seen it quoted before, for Justice Brandeis's parade of horribles about government law breaking as an invitation to anarchy. It's not off topic, so I'll give it to you. When these unlawful acts were committed by federal agents, they were crimes only of the officers involved. When the government, having full knowledge, sought through the Department of Justice to avail itself of the fruits of these acts in order to accomplish its own ends, it assumed moral responsibility for the officers' crimes. And if this court should permit the government, by means of its officers' crimes, to effect its purpose of punishing defendants, criminal defendants, there would seem to be present all the elements of a ratification. If so, the government itself would become a lawbreaker. In a government of laws, this is the famous quote you see displaced out of the case. In a government of laws, existence of the government would be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or ill, it teaches the whole people by its example. Enter the parade of horribles. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. Semicolon, it invites anarchy. Now, by wiretapping phone lines, federal agents had recorded hundreds of hours of conversations among individuals in Washington state who were conspiring to import, it must be conceded, a massive amount of liquor in violation of the National Prohibition Act. Department of Justice lawyers decided to bring charges in one conviction by relying almost exclusively on the wiretapped conversations and derivative evidence, notwithstanding the fact that the wiretapping was a crime under Washington state law. The majority found no illegal search and seizure in the case under the Fourth Amendment because the defendant's homes and, this cute legal expression, their curtilage were not entered. And it brushed aside the concern that so occupied Brandeis, inducing lawlessness in the government, with the assertion that the criminal law of Washington could not control the rules of evidence in federal court. So jurisdiction is used to avoid the specter of inducing lawlessness. So it was left to Holmes, who in a separate dissent noticed that the case involved structural resistance. And it's for that reason I give you the case. Resistance arising from contested constitutional and public values that defy any ready synthesis. Though Holmes gives you the, I think, quite concise synthesis of the defiance of ready synthesis. He admonishes that the court faced, and I'm quoting him here, two objects of desire, both of which we cannot have. It is desirable that criminals should be detected, and to that end, that all available evidence should be used. It is also desirable that the government should not itself foster and pay for crimes, duh. But when they are the means by which the evidence is to be obtained, when they are the means by which the evidence is to be obtained, it is also desirable that the government should not itself foster and pay for crimes, when they are the means by which the evidence is to be obtained. We have to choose, and for my part, I think it a less evil that some criminals should escape than that the government should play an ignoble part. I think Holmes makes the right choice, but what matters for present purposes is that neither choice avoids lawlessness, and both resonate with compelling collective interests, contested collective interests. At a more mundane, but no less important level, at least in the American context, the adversary system itself operates on, or establishes, if you will, for legal decision-making, for the process of rights definition, a structure of resistance. And I'm not just referring to the agonistic rules of procedure and evidence, but the fact that those agonistic rules of procedure and evidence are followed not by the closure of judgment, even in the run-of-the-mill case, not by the closure of judgment, but quite often by protracted and entirely new rounds of litigation over the remedy and its enforcement, which speaks to the status of the judgment. The story of Brown, to give an obvious example, is not only incomplete without, but is in fact undone by the remedies and enforcement decisions rendered decades later in cases like Milliken versus Bradley 1, Milliken versus Bradley 2, Missouri versus Jenkins 1 through 3, and all of this long before Seattle schools and Robert's little nail in the coffin. We come to know what the law is via resistance. Resistance tells us. It takes law off the books. It tells us what's going on off the books. Something like the same thing occurs in run-of-the-mill, simple private law cases all the time. I'm a procedure instructor in addition to somebody who writes about the history of the legal profession. And my favorite example of this in a run-of-the-mill case is Mid-Continent Wood Products versus Harris. It's a little case from the 7th Circuit. $29,000 of wood. Harris buys it from Mid-Continent Wood, and big surprise here, he doesn't pay for it. He's in breach of contract. Mid-Continent threatens to sue. Harris gets a lawyer. Harris's lawyer offers a settlement. The settlement is agreed to by Mid-Continent Wood Products. Harris doesn't pay the settlement. Harris is accused of breach, once again, by the lawyers for Mid-Continent Wood Products and threatened with suit. A suit's actually filed this time. Mid-Continent's lawyers are waking up to the resistance of Mr. Harris. A promissory note is entered to resolve this worst lawsuit. Harris does not pay the promissory note. A second lawsuit is filed. Harris does not show up to defend or answer in the second lawsuit. A default judgment in favor of Mid-Continent Wood Products is entered against Mr. Harris. It takes Mid-Continent 6 years to locate assets. This is the post-judgment part. Default judgment entered does not end the case. It takes 6 years for Mid-Continent Wood Products lawyer to identify assets of Mr. Harris. Those assets are attempted to be seized. Mr. Harris comes into court for the first time in the case, having had a lawyer all along, but for the first time in the case comes into court and says, guess what? You sent the notice of service of process to 13 Secor Drive. I live at 15 Secor Drive. The gavel goes down. The case is thrown out. The judgment's void for want of jurisdiction for the defect in service of process. 10 years, a debt all, including Harris, verbally through his lawyer himself, has conceded is duly owed, is not paid. Now, whatever one's view about the justice and resistance to Brown, or the injustice in it, it's exceedingly difficult, I think, to frame, and my students find it exceedingly difficult. I take great pleasure, I must confess, in their difficulty, trying to find a way to frame Harris's conversion, that's the cute common law word for theft, here of wood, and his procedural maneuvers, a way to find that theft, a way to frame that theft and the procedural maneuvers to avoid judgment. In anything like the register of justice, it's purely self-interested, quite open resistance to law, and the lesson of the case is that it's tolerated. Indeed, good lawyering for Harris requires it. Even more fundamentally, in my view, there's no constitutional guarantee of complete constitutional fidelity for any branch of our government. There's no constitutional guarantee of complete constitutional fidelity or anything like it, in point of fact, for any branch of our government. In fact, a range of doctrines precludes the courts from taking up and providing remedies for lawlessness by other government actors. From a structural perspective, what this means is that the Constitution contemplates internal resistance. And not just at the level of intergovernmental resistance endorsed by federalism and separation of powers, though that's no small thing, but by and through the unreviewable extra-legal action of discrete state actors. This is Justice Scalia. He's going to give you some gobbledygook in a constitutional chapter and verse, but I think it's worth the endeavor. This is Scalia in a case, the details of which we could talk about if you're interested. I turn then to the substance of the court's warning that judicial review of all colorable constitutional claims arising out of the respondent's dismissal may well be constitutionally required. What could possibly be the basis for this fear? Here's the key. Surely not some general principle that all constitutional violations must be remediable in the courts. The very text of the Constitution refutes that principle, since it provides that each house shall be the judge of the elections, returns, and qualifications of its own members, and that for any speech or debate in either house, the senators and representatives shall not be questioned in any other place, speech or debate clause. Claims concerning constitutional violations committed in these contexts, for example, the rather grave constitutional claim that an election has been stolen, well, actually, this is the 1988 case, he's walked back on that particular line, cannot be addressed to the courts, is the end of that sentence. Even apart from the strict text of the Constitution, we have found some constitutional claims to be beyond judicial review because they involve political questions. The doctrine of sovereign immunity, not repealed by the Constitution, but to the contrary, at least partly reaffirmed as to the states by the 11th Amendment, is a monument to the principle that some constitutional claims can go unheard. No one would suggest, if Congress had not passed the Tucker Act, that the courts would be able to order disbursements from the Treasury to pay for property taken under lawful authority and subsequently destroyed, he doesn't say it, but unlawfully, without just compensation. And finally, the doctrine of equitable discretion, which permits a court to refuse relief, even where no relief at law is available, when that would unduly impair the public interest, does not stand aside simply because the basis for the relief is a constitutional claim. In sum, it's simply untenable that there must be a judicial remedy for every constitutional violation. Members of Congress and the supervising officers of the executive branch take the same oath to uphold the Constitution that we do, and sometimes they're left to perform that oath unreviewed, as we always are. Now, it could not be otherwise, much as I like to find myself in disagreement with Justice Scalia. Without room for constitutional error, the executive branch and its administrative agencies, if you just focus there for a moment, the agencies that are responsible for regulation in the law and the enforcement of law would be crippled, which is to say that the law itself would in some sense be crippled. The only question for debate, which we have difficulty acknowledging, is in fact the question for debate, is the degree of tolerable constitutional error, the degree of tolerable resistance to law. But the areas of state resistance to law are broad indeed. Prosecutorial discretion, just about every area of habeas review in federal courts of unconstitutional state court convictions, much of criminal procedure generally, nearly all of administrative law, all fields touched by sovereign immunity, qualified immunity, justiciability doctrines that tell you when you can assert a claim in court, vast areas, as we now know, of national security. And these are not, I'm at pains to emphasize, harmless constitutional errors, the stuff only for legal scholars to be concerned with. I could here add an excursus on the Bush administration's extra legality with respect to torture, the expansion of executive power that coincided with it, the borrowing from expansions of executive power in the Roosevelt administration and the first wave of the New Deal, or from Andrew Jackson's presidency and his reliance on Andrew Tawney to secure victory in his so-called war against the bank. And add as well the post hoc political ratification of both that extra legality and of executive power by Congress in the Military Commissions Act. All of this a kind of law reform, notice, that is operating through lawlessness, here by the executive seizing the authority of initiative to act first, change the political terrain in which that action is taken, and thereby change the legal terrain in which it's evaluated, and largely unreviewable by the courts. But I hope I've said enough already to make sense of the inversion with which I began. Resistance to law is constitutive of our legal order. Borrowing from Stephen Will's lovely menu, Chris, I think is the metaphor. Law is a lexicon constructed on contested sites. Resistance to law is constitutive of our legal order, constitutive in ways I hope I can convince Chris are not merely metaphysical. So my paper for this panel is a kind of prologue to a larger project that is addressed in the first instance to the memory work of those of us who've sworn an oath to uphold the Constitution and the laws, and find ourselves quite regularly, indeed I want to suggest rather systematically, in the position of counseling resistance to law on behalf of resistant subjects. We lawyers, and no less the resistant subjects we represent, have created rather elaborate, quite vexed, and in my view, genuinely understudied narratives to diminish, conceal, and rationalize our role in resistance to law. So the paper traces modern history's debt to revolutionary resistance and to law, not so much to make a general endorsement of counterhistory, which I take it is familiar to all in this audience, as to locate a method by which we lawyers, we legal historians, approach resistance to law without forgetting our role in it, without forgetting how pervasive it is. A method that is for returning law and history to resistance, to what Wilf calls seizures, I think, quite provocatively, without letting either discipline hide out in the other. Thank you.
So I too want to start by thanking Chris and the UCI School of Law for coming up with such a provocative call and bringing all of us together. And thank Chris and Catherine and everyone else for the wonderful organization so far. And what I'm going to do is just read my paper, so I'm hoping that most of you didn't read it when it was circulated. I will make, I have actually read most of the other papers, and so what I'll try and do is I'll also try and make a gesture towards where it is that I think that they fit. I mean, the ones on this panel you'll be able to tell because you're here, but in case you aren't here for every session, you can maybe see how it is that the conference will possibly lead together. And if I don't mention your paper, it probably means I haven't read it, not that I don't think highly of it. So my paper is Law as Claim to Justice, and I am beginning by taking off from some criticisms that I received from other work that I did. So in Just Silences, I wrote that justice today lies in various ways in the silences of legal texts. And I suggested that different disciplines take different approaches, not only to law, but also to silence and to justice. And I criticized particular approaches that disregarded, downplayed, or otherwise dismissed the need to attend to silence and to justice in studying law. What I'll do today is suggest that taking seriously the difficult claim that justice lies in the silences of legal texts leads one to value precisely the kind of scholarship that recognizes both the importance of and the limitations of texts as utterances and as artifacts with their own particular provenance and context. Legal history is, of course, one such area, and hence it's an enterprise through which one can productively engage with law and with its modern silences. Indeed, I suspect, in fact I know, that such engagements already happen in legal history, so I'm taking my task today to be to exhort legal historians to continue to provoke confrontation with issues of justice and silence, probably in some ways like and unlike Norman Spaulding's talk that you just heard, that is, to provoke confrontations which other areas of legal scholarship might simply ignore or simplify at their peril. And so in this spirit, I'm going to point to several ways in which what I consider to be a rhetorically inflected legal history is particularly suited to reflection on justice in law. My points together suggest, if not quite a theory and method for legal history, certainly a defense of approaches to law that characterize the humanities and a challenge to those who fail to perceive the relevance of such work for understanding law. Legal texts are enacted and legal actions occur, whether just or unjust, in the name of the law. And that was originally the title of my paper. Like an annoying snatch of an old pop song, the phrase, "in the name of the law," refuses to go away, even though I got rid of it in my title. It accompanies legal texts and actions, even as it's difficult to pin down, and seems to have received no explicit scholarly attention. Exploring the name of the law cannot be left to studies of law that have little or no use for the way language works. Such studies of law are radically incomplete. In their own terms, this may not be problematic, but for the purpose of understanding law, these studies leave out too much. And our rhetorically informed legal history, or perhaps I should say historically informed legal rhetoric, offers welcome correctives. The rhetorico-historical study of law, as a series of speech acts that I'm going to propose, reorients current tired debates in the legal scholarship of other fields, and that will be part one of my paper. This speech acts approach to law emphasizes, as in some sense admittedly does all history, the temporal aspects of law as an event belonging to a tradition, however contested that tradition is, and that's part two. Even as this approach to legal speech acts also draws attention to the ways in which law differs from the subject matter of other sorts of histories. And my claim is that it differs, law differs, legal history differs from both law and from history, more generally speaking, insofar as law as rhetorical phenomenon and event appeals to justice. So the appealing and the claiming about justice is important to what it is that I'm arguing here. So part one, law as speech act, and this is the part where I relate it to the other fields and the call for papers. So in keeping with the terms of one of the original calls for this conference, I'm going to begin with a challenge to legal realism, which is familiar probably. Although more sophisticated scholars of law now widely disclaim the strict legal realist distinction between law in action and law on the books, that distinction still holds in many approaches to legal research and legal education. Legal realists and historians of law who turn to the empirical study of law are indeed correct that formal rules do not describe legal behavior. They're correct that legal reasoning, bereft of any correspondence with actuality, is vacuous. But in distinguishing law in the books from law in action and rejecting legal text as simply law in the books, realists, no less than theorists who would reduce law to statements of rules, as we shall see, move too quickly away from the ways in which speech and writings matter. Law and society scholarship has long shown how law acts. As a new legal realism symposium in a relatively recent Wisconsin Law Review puts it, recent law and society scholarship shows how law acts from the bottom up as well as from the top down. In the bottom-up formulation, attention to legal ideology, legal consciousness, and law in everyday life does much to fill the gap between action and doctrine. But that filling is not as satisfying as it could be. And actually, there's a paper coming up later, Laura Edwards' paper on keeping the peace, which I think might be a nicer way of thinking about that filling. So law and society continues to emphasize legal actions over legal speech, and continues to focus on power, domination, and control in and of law. As most of law and society claims then, in law as elsewhere, it may indeed be that actions speak louder than words. But using words through speaking and writing is action in a very particular sense. And what many who don't have ears behind their ears, as Nietzsche put it, do not understand, loudness may not always be what is most at issue. In the context of legal history's reliance on textual materials, and it's important to note that both law and history rely largely on written texts and their authority, a revitalized and explicitly rhetorically informed legal history could or can or does hasten the death throes of the law in action, law in the books distinction, insofar as it shows how law in the books, whether legal doctrines or some other sorts of utterances or written or spoken productions, are themselves acts, and how law and action cannot be understood through empirical study alone. Informed by an understanding of legal writing and speaking as practices, legal history reorients common misunderstandings of text as static, and then also as image-free, as you'll see in Peter Goodrich's paper later. An example of this comes in Cornelia Wisman's very excellent book, Files, Law and Media Technology, which, for instance, shows how changing recording and archiving practices accompany different sorts of governance. Different ways of circulating, depositing, hoarding, copying, pasting, deleting, notarizing, storing, compiling, and indexing characterize different forms of law. Transmission of news through oral acts announced by a local town crier, for instance, not only differ from the updating of the codices of imperial Rome, but enable or accompany a different sort of rule and administration. Further, when files become documents kept in public places rather than personal notebooks, it's possible to make copies to prove legal claims. Such an emphasis on evidence, rather than on transmitting news the way it was with the local crier, takes reality to be what's found in the file. Dispatched letters sever the links between acts and objects of transmission that characterize formal public announcements. The silent reader of a sealed letter takes its content and not its exact wording as imperial command. And she goes on, and it's a great book, I really recommend it. In grasping that texts of law involve practices of writing and speaking, legal history complicates not only the difference between an ineffective law on the books, and which you've heard about a little bit today, and a powerful, if also out of control, law in action then, but also complicates whatever remains of philosophically simplistic positivist understandings of legal power as simply commanding authority. Insofar as legal history recognizes that the legal quality of a text or action is given by its context, such history also recognizes, as indeed did John Austin himself when he defined law, not simply as command, which readers of Hart mistakenly take Austin to be doing, but he defined it as command by threats which subjects are in the habit of obeying. So he's claiming that more is required for there to be law than a powerful agent. Legal history that acknowledges both the dynamism of speech and writing and the context that's necessary for a speech act such as command to be effective as law approaches the insights of his second Austin, J.L., who famously argued that non-nonsensical utterances are speech acts whose success in any particular instance depends on its context or on what he called the total speech situation. For the ostensible speech act of command that is law to work, argue both Austins, supported by legal history and by Lon Fuller, the circumstances must be right. Or in Austin's lingo, the felicity of what he at first calls a performative utterance and then later an illocutionary speech act requires that there has to be a convention or procedure for the act that includes the uttering of certain words by certain persons in certain circumstances, that the persons and circumstances must be the appropriate ones, the procedure must be executed correctly and completely, if certain thoughts and feelings are required, you have to have them, there has to be update, that kind of thing. All parties to law today know this, that procedure matters, and we had a great example of that just a few minutes ago. Unless forms are filled out and fields filled in, all the way, on time, scanned or sent to the right office, signed by the proper parties, stating an appropriate cause of action, a street number, for instance, a claim fails to amount to a successful complaint. Just any rex, in other words, cannot make lex. And context, then, the conventions and circumstances surrounding ostensible law matter to its success as law. Now, the legal positivism that today predominates in the Western philosophical tradition, of course, associates law less with command than with a system of rules that in some sense establishes the conditions of its own production of law as law, and that has no necessary connection to justice. And here I'm thinking about H.L.E. Hart and his idea of law as a system of primary and secondary rules. And we can talk about that if people are interested. But despite modern legal philosophy's repudiation of law as command, today's legal positivism nevertheless continues to rehearse the old debate between legal positivism and natural law. And the claim, as you know, is that for the natural law people, law grounds the justice of law in morality or in a higher law, while positivism insists that there's no necessary connection between law and morality. And there's actually some nowadays who are starting to deny the salience of this debate. There was a recent lecture at Berkeley where Liam Murphy, who's a positivist philosopher who was invited to give this talk, gave a whole talk on how much the disagreement between positivism and non-positivism as to the grounds of law matters, and his answer was not much except in merely verbal ways. And I'm going to go on and talk a little bit about this gesture towards what's merely verbal. But before I get there, I want to just remind you that legal positivists and natural lawyers do agree on one thing. They agree that law, whether it's as rule or as right, they agree that law somehow tells us what to do. In the telling of law, that's acknowledged to happen by both sides of this dispute. The rhetorically savvy legal historian again recognizes activities of knowledge production, of discovery and enactment, of dissemination and receipt of law. The telling of law that all the philosophers recognized is an activity. While in principle this activity need not, I suppose, happen only through words, it does occur largely through language today, and since 19th century codification movements and 20th century restatements, largely through writings. The telling of law today, thus, is a series of speech acts. While one can contest particular descriptions or characterizations of this activity of telling, or series of speech acts that's law, surely this oft-neglected commonality between natural law and legal positivism is as telling about law as is the original dispute between them. Disagreement as to the grounds of law actually matters less than that law claims, and that's a speech act, law claims the authority, whatever the grounds, to tell us what to do. And law, often, rightly or wrongly, does so in the name of maybe what we can call justice, which name justice it has, at least at times, taken to be its own. Whether that's so or not is an open question, but it has taken that name as its own. However verbal, and you have to acknowledge that it's sometimes silent, so however verbal is law's appeal to authority and justice, this appeal is not merely verbal. The appeal and claim of law is not only a speech act, right, the speech act of appealing, the speech act of claiming, but also carries with it and follows a particular tradition. The authority and justice of this tradition is not, or at least has not always been, merely verbal, as legal histories show. And I think that probably Mariana Valverde's paper on the honor of the crown sort of resonates with this point. So law must be investigated not only as tradition, which Levy at this conference and others show can be done in different ways than we're used to, but law must be investigated also as claim and as appeal. What does law do in the claiming and appealing that is fundamental to it, and how does it do so? Through the particular speech act of claiming, it seems, law is bound, as it has been throughout the tradition of Western jurisprudence, and law binds us, or its speakers, to issues of justice. Language, not a god or a higher law, has bound law even, or perhaps especially when law is unjust, and this is perhaps in keeping with the resistance point, to claims about and issues of justice. And that's very important to my argument, is that it's language. It's not God or a higher law that binds us and binds our law to issues of justice. And I don't mean that language makes our law just. What I mean is that the claim to justice is the way in which our relation to what justice would, our relation and the relation of our law to what justice might be could possibly happen. But claiming is only one, if perhaps a privileged one, of the speech acts of law. Legal sources and actors complain, rebut, instruct, appeal, threaten, testify, swear, object, overrule, enact, appoint, find, dismiss, amend, approve, deny, declare, agree, promise, qualify, hold, sentence, and so on. Those are all speech acts. Insofar as legal history reads its sources for what they do and how they do it, that is for verbs and adverbs, rather than for the truth of their representations and for their classifications of persons and things or nouns, as is done in at least some legal education, the doings of law, its legal speech acts, emerge not only as having a tradition, but also as events or occurrences that happen in or take time. And then here I have an aside that I was just coming to this morning and listening to Kunal's paper again, which is that law not just has, but is tradition, and that how it understands its own time is going to be relevant to how you understand this, linking up to some of the other papers, but that's just an aside. Okay, so the second part of my paper is that if we now move from the idea of law as speech act to law as event in time, we can think about what the difference is in a particular case that I picked because I had it in my first year criminal law casebook. Morissette versus the United States. The usual way of teaching students to read and brief this case would be to ask for its issue, rule, analysis, and conclusion, following identification of parties, procedural status, description of facts, and so forth. And you can read Morissette, it's true, for establishing that intention is a requisite element of criminal liability, that in omitting reference to intention in statute, Congress didn't intend to create a new category of crime, that is unwitting conversion, and that, blah, 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 trial court instructions regarding intention were in error in particular circumstances. But if you read the opinion instead for what it does, which is actually how it is that it's written, Morissette becomes the story itself a speech act of the series of speech acts comprising a trial. So Morissette gathered spent bomb cases from federal land and sold them, thinking they were abandoned property. He was indicted, and indicting would be a speech act, as would accusing be that we heard so much about earlier. He was indicted under U.S. statute for unlawfully, willfully, and knowingly stealing and converting property of the United States. The trial court convicted and sentenced him. Following the trial judge's instructions, right, instructing, also being a speech act, to the jury that they could presume intention from knowingness, wrongful intention. And the appellate court affirmed speech act, with one judge dissenting, speech act, and the Supreme Court then reversed, in a speech act, this Court of Appeals decision. And the Supreme Court first dealt with the appellate court's interpretation of the statute that Congress enacted, right, in another speech act. And then they dealt with the trial judge's erroneous instructions to the jury, and the Supreme Court argued, speech act, that the jury could have legitimately concluded, speech act, otherwise, right? So you're getting the idea, right? The Court of Appeals construed admission, which in this case would be a speech act, of criminal intent from the congressional statute as dispensing with it, but the court held that where Congress borrows terms of art which are accumulated, in which are accumulated the legal tradition and meaning of centuries of practice, it presumably knows and adopts the cluster of those ideas. And you get the idea of how it is that the court then finds speech act, no grounds for inferring, speech act, any affirmative instruction, speech act from Congress, blah, blah, blah. Okay, I'm not going to go into that, but if you really want an example of speech acts in action, a great idea, a great illustration of that is in Barbara Welke's dramatic presentation through dialogue of her example that she'll talk about tomorrow. The point is that in my case, as well as in the practice of law, as probably most people here know, but doesn't often get said, the opinion, as well as other aspects of law, become one of a series of speech acts making claims about the series of speech acts making claims about law, which is itself a series of events. If events can be told, though, their import, like the import of traces in a text, nevertheless cannot be completely foretold. Who could have predicted that a medieval law writ about a widow in 1310 who fails to win back her land could become a 21st century example of the thrill of legal analysis? Or that the editing out of lawyers' names, but not those of judges in cases and casebooks, suggests to one writer that law students are not taught how lawyers in many cases, quote, had a sense of injustice, a sense of wrongness about the system, and then used their lawyering skills to bring about a change, and they were successful, unquote. As legal history moves beyond the actualities of socio-legal positivism, that's the legal realist talk I did at the beginning, the abstractions of mainstream philosophy of law, right, that's the natural law, positive law debate I got into, and the statements of rules of professional legal education, that's the Morissette comparison, to a study of particular events in contexts that take place over time, it leads one to think about the ways that justice is and has been said and unsaid in texts of law. Even the story of how a bill gets passed or fails to pass is a tale of claims as to what the law or the Constitution or the budget or whatever it is and or should be. Accounts of such claims and what happens to them lead one to think about the ways in which justice may yet be said and unsaid, not only in texts of law, but also in texts of history. Justice is said and unsaid in claims made and in responses to claims made in the name of the law, not only through the speech acts of law, but also through those of history. And the third part of my paper, which is a page long, has to do with law as claim to justice. Attention to claims as to the justice or injustice said and done in the name of the law shows how law matters. If justice no longer lies within the bailiwick of philosophy, history and rhetoric must now take up the issue of law's claims, explicit and implicit, past and present, to justice. And I think there's some of this going on in Lloyd Kreitner's paper that we'll hear later. Rhetorically informed legal history suggests that law matters in a different way than do other sorts of phenomena that are the central concerns of most social and cultural histories. And here I'm sort of on tentative ground because I don't really know what the central concerns are of most social and cultural histories. I have a kind of sense, but you can dump on me for this if you want. Okay, those histories, in my sort of ignorant opinion, seek either what is taken to be typical, from which they, like social study, aim to generalize, or they explore what is presumed unique, whether spectacular or marginal, from which cultural imaginary, secret desires, suppressed anxiety can be gleaned. Law, as speech act and event, is both typical of and unique in society. It both represents and is atypical of its culture. So law always matters in both ways then, as that from which one may generalize, and as that which reveals more than itself. The contribution of explicitly legal scholarship to history is that it allows one to consider how what is said and done in the name of the law matters. It matters not simply because what's done through law is typical or is revealing of fantasy, but because the name of the law matters to those who invoke its name explicitly or implicitly, and to those who hear it. How an act or event or claim or utterance in the name of the law has mattered is the peculiar contribution of history to legal scholarship. That legal history shows that the name of the law has mattered, thus raises the question whether the name of the law and law's corresponding character as a speech act that claims and appeals to justice will continue to matter. It raises questions as to the possibilities of law, of claims to justice, and thus of our connection to justice, which comes not so much from God or higher morality, but appears through such legal speech acts as claim. And that's what I would think would be the direction that legal history needs to go, or to say that it is already in. Thank you.
I think the drill is that we now should take a short break, and then we'll return to listen to Chris Thomas. Needs no further introduction.
Okay, this time I'm speaking in my own behalf. Or if you don't like what I say, perhaps I'll claim that I'm continuing to channel Stephen. About 20 years ago now, for another conference in which I had a hand, an old friend, Karen Arden, political scientist at UCLA, wrote a very fine essay which she entitled Metaphysics and Reality in Late 19th Century Labor Adjudication. The essay rehearsed arguments that she would soon elaborate in her book, Belated Feudalism. The metaphysics to which Karen referred were the metaphysics of the common law of master and servant, based, she wrote, on custom and precedent accreted and enforced in judicial holdings, formal rules embedded in the structure of the Constitution, unmoved by democratic or industrial revolutions, detached from their original settings, placed in a framework of concepts, the reasonability of which was defined through a process of exposition by professionally trained intellects. The reality was the material reality of the workplace that existed in two discrete moments. The ancient moment to which the rules of master and servant in their own origin corresponded, and the moment of the late 19th century into which, in their continuity, they discordantly intruded, and where they encountered an opposition, strikes, pickets, boycotts, massed industrial violence, that was, as it were, a movement out from under, a demonstration that the old principles no longer held. Karen proceeded to connect this demonstration to what she termed broader cultural currents at work in the epoch. The currents, you'll not be surprised to hear this after listening to Kunal Parker's paper and reading it, the currents of pragmatism. The last 3 pages of Karen's essay were a virtual honor roll of the anti-metaphysical club, the intellectuals, public and private, whose so-called revolt against formalism marks the moment of early 20th century American progressivism. Crowley, Whale, Lippmann, James, Dewey, Holmes, Pound, Pierce, and more. Hand in hand, as it were, labor movement and intellectuals fashioned a transformation of American politics and culture, the victory of current realities over timeless truths that would furnish the material and ideational bedrock for the 20th century's liberal politics, for its liberal legalism, and for their twinned insistence that all knowledge was historical and social. I had, at the time, 20 years ago, reason to dissent from aspects of Karen's argument, and I still do, although what's interesting to me is that my reasons now are rather different from my reasons then. But that's of no real importance this morning. I mentioned Karen's essay because it gives me my introduction to these papers in this opening panel, because they, like others we will hear over the next 2 days, respond to the historical moment that Irvine celebrated and to its intellectual creations. They do so in part because, as organizers, we invited the response. We identified precisely that early 20th century moment as the moment of invention of what we called law and, what is called law and. Law and first mooted in Roscoe Pound's turn-of-the-century distinction between law in the books and law in action, nurtured subsequently in the bosom of realism, thoroughly popularized by the law and society movement. Law and, we said, relies on empirical context to situate law as a domain of activity. It explains law through its relations to cognate but distinct domains of action, society, polity, economy, by parsing the interactions among them. Both the theory and the practice of contemporary legal history, we argued, exemplify the influence of law and, in its resort to synchronic analyses of relational conjunction and disjunction, to which it adds diachronic temporality as a further index of relationality that situates phenomena in temporally discrete empirical contexts and attempts to reveal the effect of law or to explain the reality of law by assessing change over time in law vis-a-vis that contextualizing domain, be it society, polity, or economy, from which law is held relationally distinct. So the animating hypotheses of legal history evince the same broad relational problematics that at successive moments have preoccupied law and instrumentalism, relative autonomy, mutual constitutiveness, legal construction, autopoiesis, indeterminacy. We invited those whom we contacted to consider the sufficiency of law and to mull the possibility of a distinct conceptualization that we christened law as, one which Shai Levy in his paper for the next session has identified with justification as an invitation to a re-enchanted writing of legal history. But it would be incorrect to identify the conference call as the point of origin for this session's papers, or for Shai's identification, or indeed for any of the papers that we will hear over the next 2 days. The call itself expresses ideas informed by the work of those who are here, as well as the work of others, all of whom have helped to create this as a moment, so to speak, for appraisal and discussion. Contemporary history as a professional project is full of talk of its own endlessness. History, and it is not the only discipline to have done this by any means, has fetishized the complexity and contingency of relationality to the point where relationality simply produces more and more of itself. One reads the book reviews in any history journal, one will meet serial notifications of this or that revision or reinterpretation, so commonplace that not to be revising or reinterpreting will seem somehow odd. One loses count of the number of times one is told one will be forced to rethink some conclusion someone else reached only 2 or 5 or 15 or 25 years earlier. The result is, nevertheless, that history has increasingly become its own subject. Not unfortunately in so rigorously self-conscious a manner that would lead us to a mature philosophy of history. Rather, we are, as Arthur C. Clarke once put it, out of the cradle, endlessly orbiting. This is not intended as a complaint, more an empirical observation. I am not advocating a return to the cradle. My hope is that in our maturity, if that is what it is as historians, we can discover a language, a rhetoric, a set of terms that is not instantly assimilable to the endless orbit of what Maury Horwitz, for one, has identified in conversation as nothing but moves. Moves that do not in fact convey one anywhere other than to a new site for the production of more moves, more output. The hope, of course, is naive, in that it is itself eminently and immediately assimilable to a move, and thus its expression to more output. Still, one can but hope. So it's in that spirit of hope that I turn to these papers. Marianne Constable addresses the time-honored gap between law and action and fills it with speech. Thereby, she demonstrates that the gap really does not exist. It collapses in on itself. Our attention then is drawn not to a conception of action as the only worthwhile empirical and also implicitly normative guide to law's reality, but to law as the embodiment of particular species of action, speech action, an enactment of speech, a practice amongst more practices. As speech, how does law act, Marianne asks? It acts in the name of, stakes a claim to. But of and to what? Marianne says justice. She says it in a complex way, in which the name of the law seems to be justice, as if one cannot be quite sure. The connection becomes unclear, fragmented, a conversation on which there's too much static, or perhaps, to use a metaphor that shows my age, perhaps it's a party line. In the rigor of our disenchantments, we've learned to talk of justice as evanescent, residual, drowned out. In Marianne's paper, law is positively garrulous, noisy, cacophonous. It's as noisy as the socio-legal positivism that in her book, Just Silences, is the acme of contemporary sociologized law, that is, the law of law and that she says there relegates connections between law and justice, if any, to empirically contingent social realities. Marianne proposes that the act of speech, naming and claiming, reconnects law and justice, but amid the noisy prattle of law, I'm struck by how inarticulate law is when it actually comes to speaking of justice. The observation is not intended in any sense as a counter to Marianne's proposition. After all, a stammer, an embarrassed silence, is as much a speech act as any other. What is it, however, when the speech is speech but not claim, but specifically disclaim? One example only, but it seems to me not unique. Take Roger Tawney speaking for the majority in Dred Scott. It is not the province of the court to decide upon the justice or injustice of the law, but to administer it as we find it. To name oneself justice in this particular prominent instance is to invite one's undoing. I was struck by how Marianne describes law on the books rather than in them. It's a figure of speech, of course. It led me to two thoughts. First, of books as artifacts, and of how in, for example, Kafka's Process, the trial, law is contained in books that are secret. The expression law on the books rather than in them can suggest that books are law books because that is the name on them. But what is in the books remains secret. Hence justice may be in them, but it is not read. Or, and this is closer to Marianne's meaning perhaps, justice may be secret precisely because of the name on the books. That is, one reads them only in one way. One reads them as law books, because that is their name. Justice then becomes an infusion, a ghostly infusion, spectral, a dybbuk, to borrow Asaf's lovely opening. Justice is like law in the books, waiting and hoping to be known, but only to be discovered once read distinctly. As silence, perhaps, as Marianne has argued, or alternatively not that to which law gestures in speech or silence at all, but instead that which unfolds from law not when called upon or squeezed out or tracked down and cornered, but only when it has sufficient reason of itself so to do. To return very briefly to Kafka in The New Advocate, Dr. Gisepolis does not practice law at all. He reads. He reads and turns the pages of our ancient books. The law that was studied but no longer practiced, Walter Benjamin used, was Kafka's opening to justice. If law is speech act, hence action, practice, does the practice obscure rather than connect to justice? My second thought, somewhat distinct, was of law on the books as law always poised for action, as origin, as it were, as Sprung, as coiled spring. Stephen Wolf's paper, to which I will return, gives us a succession of images of the nature of law texts in precisely this form, as a sort of latent energy, thrusting, instrumental, powerful, inevitablist, intolerant, hungry. For some reason, this is, for those of you who read Harry Potter, remember the Monster Book of Monsters. And think of law books as monster books of monsters. They have to be bound with a belt to keep them shut, because otherwise they will come out and bite you on the ankle. Can justice ever inhabit texts such as these? Kunal Parker's paper whets one's appetite for his book, though I should, of course, confess immediately that I have an interest in his success because I'm the editor of the series in which his book will be published. Here too, though, we encounter a gap, as it were, a blank, created by intellectuals' insistence on emptying 19th century life of its phantasmagoria and filling the void with the incessant hubbub of their reflective intellection. What is drained in this particular instance is the common law, invoked by Kent early in the 19th century as the water of life, determinedly sucked out approximately 80 years later by the American legal tradition's reigning eviscerator, Oliver Wendell Holmes, Jr., who dissolves both life and law in the acid bath of nothing but history that is to be the fate of the 20th century to encounter and endure. To my eye, Parker's invocation of the common law is elegiac almost, in the full sense of the word. That is, it mourns that which is irreversibly dead. It does not yearn romantically for its revival. But what is most decidedly his achievement, it seems to me, is to show how, by paying attention to their antecedents, two of the most relentlessly positivist of scholarly discourses, namely modern American history and modern American law, both stand revealed as settled knowledges, while simultaneously each by reference to those antecedents is reinfused with the capacity for a certain mystery, and thus invigorated in their capacity to unsettle settled knowledges. And here I'm following Kunal's reading of Carl Lewis, whom I have not myself read, but without necessarily paying as a price of that capacity the exorbitant exaction demanded by what we've come to call postmodernism, which is that knowledge shall never ever settle again. What I mean to suggest is that what was science the first time around maybe can do a second lap as metaphysics. What might happen if we were to reinfuse Wilf's hungry law books with metaphysics? That same thread of metaphysics, I think, binds Norman Spaulding's resistant subject into the fabric of this morning, although the weave is certainly distinct. The subject's resistance, and hence chance for awareness, lies in the possibility of refusal. Refusal to be bound, refusal to be completed, refusal to be ended or contained by anything, law or politics or history, and in holding the moment of refusal itself indefinitely open. I'm reminded of Bertolt Brecht's this destitute cripple, George Fucombe, in Threepenny Novel, who dreams the day of judgment, the greatest arraignment of all times that would judge the living, the dead, all who had in any way wronged the poor and defenseless, and who awakens from his dream to find that he is himself the condemned. In the moment of Fucombe's awakening, his arrest and his execution, Brecht annihilates the possibility of a relationship between justice and law. The oppressed will not be rescued by dreams. The question rather is the knowledge one possesses at the moment of awakening, the knowledge one brings to bear on the materiality that presents itself when one wakes up. It seems that society has the last word by hanging George Fucombe, yet in that waking moment, he has understood how ancient is the crime to which he and his kind fall victim. Law reminds us of the price that accompanies refusal. Sort of an unbounded awareness is as ontologically terrifying as the finality of death, and is hence as much an occasion for avoidance as that first scene which he invokes in his paper. Terror urges us to displace, to trim, to contain, or to complete our resistance, or to have it completed for us on our behalf by structures of law, politics, and history that undertake completion by rematerializing the subject in compliance, a consenting legal subject, a settled knowledge. I think here I'm not sure that we are quite as bereft of means to apprehend the possibility of a distinct subject position as Noam argues in his paper. I wondered, for example, when agonists, like my colleague at the American Bar Foundation, Bonnie Honig, stand in Noam's account of contemporary political theory. At the intersection of law and history also lie those like Cornelia Wissmann, already mentioned by Marianne, and perhaps in a very different way, Carol Pateman, whose work in both cases seems not to assume the legal subject, but rather to trace the means and media of its construction as such. I agree, though, that what I take to be the larger point, that if our history is not to dissolve into law, then our task is to write legal history without necessarily assuming law. To do that, one must be able at least to imagine history without law, or at the very least imagine how to write of law's beginning and end. But then the question arises whether this is not to dissolve law into history, as Holmes did, and hence pose just another form of completion. It seems to me one must therefore know how to write of the beginning and end of history too, unless one is to hold history up as the one allowable universal critical solvent, and hence the one allowable mode of completion that completes everything except itself. Resistance in Norton's sense is precisely to resist completion, to hold open a fissure rather than close it. This is precisely why, in my view, his resistant subject properly belongs to the fabric of metaphysics, although after listening to his presentation this morning, I begin to see why that is not necessarily the case. Let us remember, though, that the counter-history, which Norm invokes in his paper, of which Foucault speaks, the counter-history to that which pacifies society, justifies power, and founds the order that constitutes the social body. This counter-history that shows that laws deceive, that kings wear masks, that power creates illusions, and that historians tell lies. This counter-history, that is the resource of the resistant subject, necessarily dwells in the realm of the metaphysical, for it is a history that relies on outwitting the trick, on detecting the secret, on deciphering the truth that has been sealed, on detaching its subjects from their given historic juridic consciousness and locale, in order to introduce them to a form of history and time that could be dreamed of precisely because it may not be known. Now, I said a few minutes ago that Canal's paper whets one's appetite for his book. It seems not unkind, and I have no need or I have no desire to be unkind, for I value his friendship, to say that Stephen Wilf's paper whets one's appetite for, as it were, the rest of his paper. Stephen has written us a menu for a feast that comes accompanied with more than enough tastes of hints of what's in store to set one salivating. I will spare him the inevitable allusion to slow food. Let's instead begin with the sign over the restaurant door, as plans for this event were coming together, and we corresponded about his participation. We corresponded about possible titles for what he intended to write, and Stephen sent me the title he chose as one of two, and I said, I like that one. He then responded that he did too, and described it quite unforgettably as the enunciation of a new genre of legal history / non-fiction. I can't think of a better interpretive term for a pursuit that exists at the junction of two distinct bodies of text and practice, that to make sense, it must keep distinct and simultaneously bring together in time and at the same time. Throughout, as in all great cooking, one's palate encounters successive subtle contrasts in flavor in Stephen's paper. The gentle astringency of a fine vinegar seasons his account of the state of legal history, the doing of what we do, a judicious dusting of time, or perhaps the satisfaction of a well-aged cheese serves metaphorically to caution us against too rash a pursuit of methodological faddishness. When I came to Kundera's dictionary in Stephen's paper, it made me pause to look at another, Ambrose Bierce's Devil's Dictionary, which may be familiar to many of you. Bierce dyspeptically defines law essentially as power, history as lies, and justice, I quote, as a commodity which is a more or less adulterated condition the state sells to the citizen as a reward for his allegiance, taxes, and personal service. But of all Stephen's devices, the richest, I think, are Blake's telescope and Galileo's observatory. I hope this works. Yes. Because Blake's telescope and Galileo's observatory bring irresistibly to mind a third optical illusion, perched temporarily more or less between them, William Hogarth's utterly unforgettable 1724 engraving that will be known to many of us, entitled "Some of the Principal Inhabitants of the Moon as They Were Perfectly Discovered by a Telescope, Brought to the Greatest Perfection," and known more simply as royalty, episcopacy, and law. As you will see, I hope you can see, royalty's face is the coin of the realm, around its neck is a string of bubbles. Cloven-hoofed episcopacy works a money pump. Law is a hammer in a periwig. Like Blake's telescope, Hogarth's telescope has magnified its objects. It has not touched them. But here is no problem. It need not touch them, for in gazing upon them, it has penetrated them. It shows them as they are. As in Galileo's observatory, simple observation is indeed the beginning of heresy. As readers and writers of texts, interpreters of objects, and tellers of tales about them, we can learn a lot from the engraver's eye, particularly this one, this engraver, Hogarth, who was so great an observer, and with it also so great a theorist of observation. The god of gates, and of those who keep them, Janus, is these days the most popular of academic gods, particularly in our practice of purposefully directionless direction. This morning, Stephen's paper named Janus the god of legal historians. Once more, it seems we are catching up to the curve. We're way behind the curve in this particular case. More than 150 years ago, Maxime Ducamp, author of Paris, its organs, its functions, its life, anointed Janus god of history. History, he wrote, is like Janus. It has two faces. But he added dryly, whether it looks at the past or at the present, it sees the same things. In a sense, I take Stephen's advice in his paper to be not that dissimilar. As legal historians, we can be Janus-faced, but we need not be so respectful of the claims of difference that the twin objects of our attention, law and history, insist on making for themselves. One may have an eye for each, but the advantage of having two eyes is supposed to be that it improves one's sight, not that it condemns one to a life of double vision. Each of these papers this morning, in its own way, encourages me to believe that we can look with two eyes, and if we look carefully enough, we can see that what appears to be difference or dichotomy may simply be distinctness. As speech, act, law can be action, practice. As metaphysics, law can be history, and history can be law. And in the moment of waking up, the resistant subject's knowledge can settle upon what has unsettled the subject. And so, to finish with Penelope, the day need not unravel the knowledge the night has woven. Thank you very much. I think at this moment, what we hope, what we ask, what we encourage is interventions, discussions, questions from the floor, from the panel. anything of that nature. We have microphones down here. The format of the room is such as to make free discussion not easy, not difficult. We hope you will engage with each other as much as direct your attention, as it were, back and forth in a bilateral way between audience and panel.
Maybe could people identify themselves as this? Yeah.
Ken Shakespeare, Miami, and this is a question for the conference. I'm here as a lawyer and not as a historian, although as an academic lawyer, a central part of my legal practices are doing history. So I took the conference title literally, law as, and I read all the papers seeking to find a lawyer doing history. I discovered, of course, that there were none. I did discover a couple things. One, that law as history already has some proposed disciplinary discipline. It's in some way about closely reading texts, and not just in Stephen Will's explicit terms, but in many of the historians' presentations. And the second thing I discovered is that the papers were quantitatively balanced between historians who were engaged in what one might say a neo-rationalist enterprise. What can history give us as a purchase on law and legal practices? And then there are a group of loosely irrationalists, Nietzscheans, discourse deconstructors, psychoanalysts, imagists, and they, of course, question the ability to do any kind of rationalist purchase on legal practice. Now, as a whole group of texts, aggregate texts, the revelation is that both the neo-rationalists and the irrationalists depend upon each other dialectically, and we have to invent the other if the other wasn't already present. So the historians are worried about the degree of rationality in their claims, and the irrationalists are extremely rational in the presentation of their position. So why is this bothersome to a lawyer? Well, a lawyer, it seems to me, is always engaged in strategic representation. And as such, it seems to me problematic that we always teach our students to use official case reports, statutory language, legislative reports, all of which, of course, are documents of history, all of which, of course, are winners' history. And that we don't teach our students to deal with the context of the production of law, which, following E.P. Thompson, I take to be both an arena and form of social struggle. So we don't do much representation of the losers' histories involved in all of these continuous contests. And of course, that means we don't recover what are not the same, but often are, lost voices. So the question that this raises for the lawyer as a strategic actor is what do the participants in this contest do about lawyers doing history as strategy, and why are the legal historians seemingly drawn to working with, against, about, through winners' documents?
answer. Somebody want me to answer?
Does somebody want to answer or start a new thread?
Ken, you pose that as a, it strikes me you pose that as in part a rhetorical question to which you may have an answer yourself. Even if your answer is one of, I think what you guys are doing is bullshit, it would be good to parse it out, I think.
Well, lawyers, as engaged in strategic representation, are always looking for more tools of strategy. The paper that I felt closest to, actually the presentation, not the paper Spalding, but the live Spalding, was about law not being understandable except as resistance to law. Well, that's a kind of external content within the production of law. Sure, it recognizes law as inherently contested and struggle over power, but it doesn't lend itself to an interior legal practice, which is based upon the struggle of different groups continuously, as witnessed in episodes, over power or the legitimation of existing conditions. As a lawyer rather than a historian, I want to try to increase the interiority of legal practice as contested and always in a legitimation crisis. I think there are good ontological and epistemological reasons why that's a good strategy.
I think several of us have actually not answers, but maybe responses. I mean, one is that this goes back to the law and society legal realism problematic. That the problem of legal history in the context of law and society was that sociology and political science and economics had at least a self-presentation that they could be useful. History never had that presentation, so legal history always, in a sense, failed, was always a stepsister within the law and society context. So one side of it is that there is the sort of law office history problematic, which always seemed like bad history, and there are generations of critiques of that. Law and society never seemed exactly to work. I take part of the law, part of the response, and to vastly oversimplify, is that doing legal history is also a practice. It's about people reading about a way of understanding the world that is different than being useful to a lawyer or being useful to lawyers. It is a form of liberal education. It's a form of opening up possibilities and alternatives. That may not just to use the sort of old-fashioned 50s language, or the sort of Llewellyn-esque language. Morty can trash me for that. Does that have cash value? That's a different question. But there's a different. But I take it what's going on in this room and what has happened in recent legal history, and to go further, what's happened in recent law and society work, is to challenge the sort of cash value for law understanding of the practice of what we do.
Yes, but that's the contrast, though. It's lawyers' strategy or strategic representation has cash value. And there's no self-consciousness about it.
Yeah,
I would only just, I guess, I'm not sure it's my position to answer the question as a panelist who does not hold a PhD in history. Question doesn't seem posed to me. But I do want to say that with respect, it seems to me to turn on some false dichotomies that it seems to me precisely the objective of the presenters here to pierce. So let me just line two of them up. The idea that case law represents winner's history would depend on taking a very thin time slice and evaluating. We may do that in the classroom to our error and to our students' detriment. But I don't think even if you took the domain of law to be represented in cases themselves, you would find winner's history. What you find is a series of really interesting reversals and losers who are becoming winners and losers who are shifting position, winners who are shifting position, winners finding ground, eroding under them. If you take a kind of diachronic perspective, that I think becomes readily apparent. So I'm just not sure that there's a lost history on the side of looking to law and only finding winners. That view, it seems to me, not to be a historical view of law. And then on the legal representations as strategic, it kind of leaves implied that the other representations, the ones you heard this morning and going to hear tomorrow, are not strategic. And also that law can't be capable of non-strategic representation. I think precisely there, again, the idea is to erode that false dichotomy and to pay attention to the respects in which law wants and promises something other than strategic, which is in fact strategic, and in which historians and academics and legal academics are engaged in the same enterprise. I take it's a fascinating, I guess perfect is the word to use, first question for the conference. But my gut reaction to the question was that it is entirely appropriate for those present to seek to find means of approach to law that are, if you will, outside the church. And I think what we'll find, in fact, what I think I've tried to argue both in the paper and in my presentation, is that when we get outside the church, we're going to find lawyers and clients there too.
Well, I'm not positive that I understand the question, but what I would say is that when lawyers are engaged in strategic representation and that law students are not taught enough about context, that this is precisely the claim of Beth Mertz's book on the language of law school and learning to think like a lawyer, and that, as Dirk has mentioned, the Law and Society movement was an attempt to try and get to those contexts. The limitations of Law and Society is precisely that the context it puts law in is as what you call a struggle of groups over power, and that if you take for granted that the lawyer's practice is necessarily about the struggle of groups over power, and you look for tools regarding power, you're not going to be very successful at resistance or at justice, which really, I would think, motivates and underlies, although you don't acknowledge it, the struggle of the groups for power that you're dealing with. So I think what some of the sort of probably the papers that you're considering as irrationalist and sort of involved in Nietzschean or deconstructive or whatever it is you put together there are doing are pointing to the limitations of the instrumental analysis of lawyering that doesn't realize that characterizing it simply as a struggle of groups over power is not exhaustive of what lawyers like yourself do.
Should we take other questions? Mariana?
Mariana.
Mariana?
Yeah, hi.
You
I have
just
a question.
identify yourself
Oh,
quickly, just so.
sorry. I'm Mariana Valverde. So I do have a question for Kunal, but I just can't resist adding a historical correction to Dirk's account of law and society, because that's a very American perspective. I have to say, I mean, the domination of the law and society movement by hardcore positivist kind of social scientists is uniquely American, and I really object to people talking about the law and society movement from that US-centric perspective. I mean, in Canada, the whole law and society movement was led by legal historians, and in fact was monopolized by legal historians for about 25 years, and sociologists came to it very late. So I just think, I hate to correct Dirk as an eminent historian, but really, in the context of this conference, I think it's important to recognize these differences. Anyway, but I have a question for Kunal, which is about your use of the term metaphysical, which troubles me a little bit, because it seems to, in a sense, sort of, cover far too much. Like 19th century historical sensibilities certainly were often teleological or Christian or, whatever, but to call all of that, metaphysical, I sort of wonder if there aren't some finer kind of divisions, because, whether you're a pragmatist or whether you're a Nietzschean, you sort of denounce any kind of teleology as metaphysical, but I don't think all teleology is metaphysical. I mean, you can have Marxist or materialist teleologies, or you can have liberal humanist, teleologies, and so I just sort of wonder why you picked that term and exactly what work is it doing.
Maybe do I need the mic? Or so
Actually, the tape.
Oh, this works too. So yeah, I mean, I was recently sort of taken to task by an academic philosopher. I'm sorry, I was recently taken to task by an academic philosopher for precisely my use of the term metaphysics. And my response, so there are a couple of different responses. I mean, one is, of course, I have no interest in making a claim about metaphysics and anti-metaphysics from the perspective of any a priori understanding of what metaphysics is or isn't, but rather that it is in fact one of the languages one of the historical languages of the period itself. Right? There's a sort of very self-conscious sort of premising of a historical consciousness that emerges in the late 19th century against metaphysics. So I sort of build on that, and then also I would say, secondarily, these kinds of discussions in the philosophy of history on history as sort of directionality and so on. Metaphysics is of course a very broad term, which you can find, so you can find causation as being about metaphysics, for instance, right? And a whole bunch of things. And I'm using it in more limited ways. So maybe I take that criticism as a helpful corrective.
Yes, right there.
My name is Matthew Crum. I'm a graduate student at UCLA in history. My question was for Professor Parker as well. I really enjoyed all the papers, by the way. I thought they were extraordinary. I have sort of a historiographical objection maybe to the metaphysical thing, which is that, I mean, you might be giving Oliver Wendell Holmes way too much credit, because even sort of historians of ideas, theorists, thinking of someone like Reinhard Koselleck or something, would date what you're talking about, a very similar thing, to the early 18th century. Right? There are people like Pocock who would say, no, Koselleck's giving the Enlightenment way too much credit. This historicism happened in the 16th and 17th century. That's when they decided to get rid of this juristic, wholesome, totalizing natural law and metaphysical stuff. Right? And I thought Professor Spaulding's paper really used the relationship between what Pocock and Foucault were doing in this kind of revolutionary, early modern Reformation moment. And the word metaphysics is problematic, not just because it's, I'm not a philosopher, so I don't want to get into debates about what that means or anything, but it's problematic because it oversees the complexity, which I think you're partly drawing attention to, of historical thinking before what we think of as historicist studies of the law in the 20th century. I'm thinking of legal antiquarianism, the explosion of historical scholarship in the law. I mean, you know, when Hume writes his histories, is that metaphysics? He would roll over in his grave to a certain extent, right? I mean, when Jefferson collects the laws of Virginia, is that metaphysics? He'd roll over in his grave at that, right? There's a series of critical kind of pieces of the legal history of before this sort of epic-making division you're making that sort of suggests a kind of counter-narrative. And I was wondering, just as sort of a final point, where you would put something like Larry Kramer's recovery of quote-unquote popular constitutionalism in your narrative of where metaphysics and historicism sort of meet each other.
So you're absolutely right, of course, that you can date your story in a million different places, right? And so that's been done. So one could think of what I'm doing really as a set of temporary concerns to be left aside once I finish the book, which is that within, I would say still, within the telling of the history of American legal thought itself, Holmes occupies a sort of pivot position, right? And you could very well make the argument that he is less central, but we have made him central in an important way. And so I take it, so that was one of the starting points of, I think there's a shift in the way in which not only American legal historians think about the past, but also the ways in which the law students are taught, right? During my first year in law school, we had a, quote, legal realist bridge session in the first semester where we were sort of told about the innovative nature of legal realism, right? So I think it's a very important part of the way that story has been told. Having said that, you know, what I'm trying to do is not so much to diminish the importance of Holmes or people that followed. Holmes is, if you like, a sort of label, right, that explains what follows upon it. Not trying to sort of demonstrate its lack of newness, right, as much as to sort of show that newness and a lack of newness, producing a relationship between newness and a lack of newness, is precisely the problem that the relationship between law and history sort of revolves around, right? It's the same kind of structural problem, I would say. And I'm afraid I have to apologize. I have to confess that I have nothing to say about Larry Kramer's book because I have not read it. So I can't talk about it. Sorry.
Chris wants to.
I just wanted to add, that indeed it may be entirely appropriate to argue that a phenomenon, an intellectual phenomenon, has, you know, earlier roots or earlier manifestations or whatever. There is this sort of game that historians play, which I have played at times, which is to say, you're wrong because I found your phenomenon in an earlier moment. Therefore, your phenomenon is kind of disallowed. I don't mean that that is your particular point, but humankind continually reinvents the same things over and over. There is no reason that because Pocock, for example, may discover a phenomenon of historicizing in 17th century thought, that Holmes cannot rediscover and conceptualize as original thought the same phenomenon at the end of the 19th century. They don't sort of, the one does not cancel the other. We're not on a ladder of progress. I think we can dispense with that.
Can I just add something really, really briefly? I think that, just picking up on what Chris said, and I think this was very much what I wanted to do in this project, is it's sort of important to be able to hold on simultaneously to the idea that something is new and that something is old, right? That something is both similar to itself and different from itself. And what I would take from that is my own commitment to taking seriously the ideas of the people that I've worked on, right? So it is in fact the common law representation of itself that drives my understanding of history, right, rather than the other way around. And so in the mode of, one could say, kind of Marilyn Strathern's anthropology, right, where in fact this is the form of the object you study that in fact shapes the form of your anthropology. That's sort of what I wanted to do, sort of really take seriously what common law thinking was as a way of turning it back, if you like, as a light bulb on my own work as a historian.
Yeah, I mean, I could just say real quickly, I don't want to take up other people's time, but I mean, I think that's absolutely right, those points are well taken, but it just seems to me that, I mean, if you've already decided the common law is fundamentally ahistorical, that the temporality of the common law is ahistorical, you're going to get a series of already sort of deciding to a certain extent. And I just, in the introduction as a historian, there's so many sort of historiographical counter-narratives that are there, and it's obvious that you know that they're there, but you don't seem to sort of argue with them explicitly, I guess. And I was just wondering how much they were there behind your thought and where they went.
Yes.
I'm not a professor of law or professor of Carol Pasternak. I'm not a professor of law or professor of history of law. I'm a professor of medieval studies at UC Santa Barbara, interested in the history of the subject and turning to legal discourse in the early and later Middle Ages as part of that, as windows to part of that history. So I have a question for Professor Spalding. That's just a straightforward question. I found very interesting both your written paper and your presentation, but what I'm wondering is in your oral presentation, the resistant subject that you present to us is very much a person who's saying no. I'm not going to follow the law. Could you make a connection for us between the more psychoanalytic resistant subject that you discuss in your written paper and the one that you presented orally?
So part of what I want to say is just a practical thing about particular constraints in research agenda, and the fact that I come to this larger project both as someone interested in the theory of resistance and as somebody who still practices law, pro bono anyway, and teaches and writes in the area of legal ethics. I spend a lot of time thinking about how to instruct and to exhort and to challenge people who are going to exercise a tremendous amount of social power. There's no question about that. In their fidelity to law, in their conception of their fidelity to law. So that has prompted me to take some of the psychoanalytic stuff seriously. It's prompted me to, as I think I used the metaphor of digging early on in the talk, and I mean it seriously. I found myself digging past the ethics codes, digging past the standard conceptions of legal theory to get at something that matches what I see lawyers doing in practice. Interestingly, I'm not sure, actually it's interesting, it doesn't quite capture it. What I see lawyers doing is trying to find ways to say yes to clients whom others believe they should say no. So it's a complicated relationship and position that the lawyer is in. It is not just as the voice of the prohibitory power of law. And that complicates, of course, when one looks to the psychoanalytic side, it says, who is the lawyer representing? Who is the client? Is this a subject? Is this a legal subject? What does the client want? What can't the client say? She, he, corporation, it, class action class of plaintiffs or defendant class it wants. But let me just try to give you the register in which which kind of pushed me into the psycholytic account. I have struggled since I first read Discipline and Punish with Foucault's injunction to turn away from sovereign power, from juridical discourse, and to look to the operation of disciplinary power. And his, I think, kind of critique of law and legal discourse and political theorists and historians for being so caught up with the story of sovereign power and not that of disciplinary power. And it seemed obviously right to me. And then immediately, as a lawyer, and as someone who thinks and writes about legal ethics, incomplete as an account of law, kind of impoverished conception of sovereign power or the relationship between sovereign and disciplinary power, or if you will, some of the appropriations of that. That pushed me back to Lacan, who describes censorship, the psychic censorship, as law, as the operation of law, and also wants to capture something like the linguistic structure we all come into, the symbolic order, as law. But also wanting to describe and to take analysts to task for failing to question their own desire and their own resistance and the way they approach the subject's resistance to analysis. So it's trying to think those two things together, or to push them together, the intersection and interdependence of sovereign power and disciplinary power, and Lacan's account of the subject. And I think that has a tremendous amount, though lawyers aren't eager to ask the question, to do with the counseling moment where we hope or want the lawyer to say no, or the client is saying no, and it's the lawyer's job to emphasize that yes is actually the answer.
Where to start? Go ahead.
Hi, Justin Richard at UC Irvine. My question's for Marianne Constable, and it's a question from a fellow traveler, as you know, in the sort of legal language and discourse analysis world. And my question is this. So I very much find value in and pursue in my own ways this sort of effort to collapse, as Chris described it, the distinction between law and, on the books and law in action, and the effort to sort of say law on the books is law in action, it is legal action. And I find Speech Act theory so felicitous for that purpose. But I sometimes wonder, and I've often wondered for myself, the reason why I think I find it so felicitous is in fact because law was so much the inspiration for thinking about the performative force of speech, right? And the same thing with Peirce. I mean, Peirce in his pragmatism, his semiotic, turned to Nicholas St. John Green and Oliver Wendell Holmes for the argument, for the conceptualization that words do things, right? So then, are we just in a vicious cycle here? I mean, is it biting its own tail to then turn Speech Act theory back? I mean, is it turning it back to understand law? Are we getting anywhere? Is it felicitous then to use Speech Act theory to understand law, or is it just colluding in reaffirming the force of law by using it to understand it? And this is, maybe this is not, I don't know, maybe this is a question that only you and I care about, but I think it's one I'm constantly grappling with.
If I understand your question, it has to do with how extensively it's already known and to some degree written or assumed that legal action is speech acts, and that whoever it was, I forgot what I was talking to this morning, who said, about how sort of the term, when law becomes operative, right? Or it's hereby determined, or sort of the operativeness of law.
It is so ordered.
It is so ordered. We know at that moment this is what makes the law be the law in that speaking, right? So everyone knows that already. And so your question is, well, what else is going on here? Aren't we just repeating what it is that in some ways has been known for a while. And I think the difference in what it is that I'm interested in is how it is that drawing our attention explicitly back to the claiming that goes on in law has to be a claim to something, whether that something exists. And actually this is a response I have to Chris's comments, is because it's not necessarily the case that there's justice out there or in here and there's law somewhere else, and that law connects to that other thing through speech. It's that the speech acts of law are what it is that enable whatever it is that we think or do or have access to and somehow name or invoke as justice.
Right.
And so I think it's that link to justice is not at all what, Austin or, the people who are explicitly doing speech act theory are thinking about when they're thinking about law. So I would say that it's the corrective that speech act, that thing about law as speech acts is able to offer to other fields having to do with law, like philosophy of law or sociology of law, which is the important thing about legal speech acts. Does that answer your question?
Well, I'm amazed that you had an answer for me because I've been puzzling with this. But it gets there. I mean, what I'm hearing is, it's something that Paul Kahn in Reign of Law calls this the appearance of law. And it is its appearance that makes the difference. So how do we know the difference between legal power or political power, right? Or juridical power has to do with the how it appears, and how it appears is in this discursive modality or whatever,
right,
it's in the language.
Discursive and traditional one, right?
Right.
And that's important because otherwise you lose the connection. You have to have both to have the connection with justice.
Chris?
No, I guess I just wanted to ask Marianne a question which leads on from what Justin has said, and in response to your response. Because it occurred to me actually as I was delivering my comment that, perhaps this is a stupid question, but what distinguishes what you're doing from ethnography? Are you doing an ethnography of speech, in effect?
Tell me what ethnography is.
I mean, ethnography is what Justin does.
Well, Justin does ethnography. Oh, huh.
So, I mean, do you see the point of the question? I wonder if you have a response in that case, whether you see Marianne as doing exactly what you do.
I think what Marianne and I do is very similar. I think that we come from different traditions, but what I do see is the question always being, okay, so what is the performative force of speech in these moments? But then also you're saying it's a claim too, but it's always a grounding in a particular moment, right, with habits of being and habits of discourse and habits and traditions that you're speaking to and bringing forth, but also making anew. And so it's like it's presupposing and entailing at the same time. And in that respect, I completely agree. What I find so hard to do, and this is where the question goes, is, right, and that's what law wants to constantly do, very explicitly and very, understands itself as doing. And so it's a slippage, right? We are constantly slipping between the analytic eye and being able to say, aha, look, we found something very interesting here. And then wondering, aren't we just sort of saying, right, and law is powerful? I mean, I don't know. And reinscribing its authority and stuff. I don't know. But whether it's an ethnography or not, I'm not sure if I know where you're going with that, Chris.
Let's take some more questions.
Yeah.
Yes.
Okay, this is just another way.
Again, identify yourself.
Sorry. I'm Ritu, also known as Ritu Virgo from the University of Toronto. So this is just, very briefly, maybe another way into this. And that is to return to the question of the subject, but also the question of agency. because, Marianne, I really appreciated your point that what we're trying to do here is not simply address law in its instrumentality, which is the dominant way in which law is taught and addressed, as far as I know, as a historian in law schools, and indeed addressed by lawyers in a kind of utilitarian way. And so the question about agency in law requires us to really think through the relationship between agency and instrumentality. Marianne, I'm coming down from a paper I just gave at Columbia Law on excitable speech and the slippage in what I read as a slippage. I'm now just shamelessly self-promoting my paper for tomorrow, but the slippage between laws logos, sovereign command, and laws nomos, inhabiting. And the reason I bring it up is that I would ask you, and also Norman, and also Kunal, to elaborate a little bit on what kind of subject you are imagining when you are problematizing law and history, and what kind of agency you're imagining. Because my problem with Austin, a sort of more traditional reading of Austin, not the Butler kind, is that it presupposes an intending subject. That's the figure of law is the intending subject. An a priori intending subject. It seems to me that all of your gestures are problematizing that, but you haven't named that. Norman, it's interesting to me that you use the word resistance rather than complicity. Perhaps we might think of all of us, subjects as complicit in law, right? So what would it mean to rethink the name resistance as complicity? And then Kunal, the subject of common law is this effect, this subject effect, the people. And it would be interesting to think about elaborating the relationship between agency and subjectivity just on that ground. So just a very open question about what kind of agency, in what ways your interventions actually problematize law and agency, not just law and history, because history sometimes is a stand-in for agency.
Sure.
I just want to say one thing first. The previous person is the author of a book called Arguing with Tradition. Sorry, but in terms of your question about what kind of subject is being imagined here, and doesn't this presuppose an intending subject, I think you're right, yes, that Austin does presuppose an intending subject, but that's not all, right? He says that there's a limit.
What are you talking about?
JL. JL Austin. Okay. How to do things with words, right? His conditions for what it is that makes a speech act felicitous require more than that the subject intend, right? And so that's what I'm most interested in, is what else, right, what else there is than what it is that law presumes as willing and intending somehow, right? So it's the subject beyond what is intended that's at stake here.
Okay, so like in 30 seconds, the subject.
Yeah.
Agency.
Yeah, and agency.
Everybody gets 30 seconds.
Yeah.
So first, I'm really interested in moving away from a certain conception of law as text. That is to say, the one that's dependent on appellate judge as high oracle of law, and the courtroom as the site of the articulation of the law, the place where the speech acts that might give us law actually meaningfully take place, or where their meaning is actually found. So I'm interested in after judgment, right, and what happens after judgment. And there are, I could give you there are an astonishing number of, if we get off of and away from, though not escape, Brown, look before rather, an astonishing number of cases that we repeat, we rehearse, we teach over and over again, the post-history of which is extraordinarily revealing for the question of resistance, and I might say agency as well. Not an intending subject. I'm not as interested in that, and don't take psychoanalytic theory to lead us there, but rather to a wanting subject. And in the relationship between attorney and client, a relationship of displaced agency. which raises questions of definition on both sides for the object that is wanted. And so it's that I want to interrogate in the larger project of this paper is just kind of a way of me kind of clearing some theoretical ground to go there.
I would simply say very quickly that, since I'm often accused of being structuralist, that you know, what, I'm sorry?
I said like Foucault.
Like Foucault. But I think that what I'm trying to do might in fact be named in the ways that you're suggesting. But what it would add to sort of draw out of there and sort of enter your language is something perhaps that we can talk about. Okay. So.
We'll have a cocktail.
Catherine.
So,
Who needs no introduction?
I think everybody knows who I am, in this room at least. So what I heard among the papers, and that particularly emerged in Ritu's comment, has to do with where we get when we say law as opposed to law and. And I'm interested in what the panelists think about. What I heard in each of your papers is the porousness about law that using as gives us, where if we use and, we envision law as something with fairly impermeable boundaries, and we can argue about what's inside the boundary, but it's very much about drawing a circle that puts something inside, and that's law, and then out of that is society. And what I thought was really interesting, I think, in Norm's paper, but then it makes me sort of ask an interesting question about Kunal's paper, is that Norm's paper explicitly invites this idea of the permeability of where law stops and something else starts, as you said right now, through the after judgment, and that you can't understand even what law is if you don't think a lot about what happens after the judgment. And the person who wins the judgment often wins nothing and winds up being the loser for it, as any lawyer who's represented, for example, a plaintiff in an employment discrimination case would tell you. You might be worse off than before you started. And then this idea of resistance, therefore, is kind of necessary to understand what the law is, because it's sort of what it does, Marianne says, but we don't even always know what it does, particularly as historians, because it's so hard. And the big project of legal history, at least is the way that I sort of learned it, is, and what a law and society inspired kind of legal history is to try and get it, breach that barrier between what we think the law is and what it really winds up doing or wound up doing in the past. And so Kunal's paper seems to me to be very interesting in this way, in that the common law is the it in the paper, and your paper envisions the common law as being less permeable than it is sometimes described as being. And that's precisely what makes your paper sort of interesting, is that everybody who reads it is asked to envision, we know what the common law is, and I kept reading the paper saying, well, I'm not sure, I've never really known what the common law is, and it's the slipperiness of that makes it's the slipperiness of what the common law was, in a way that accounts for its surprising persistence through time in the U.S. And so I'm just curious about this idea of the permeability that we get when we think about as opposed to the ampersand. Or not.
I would just say that when you talk about what law is as what law does, that it's important to distinguish thinking of what law is as a noun versus what law does as an activity versus what law does as an effect. And in part, when people think about what law does simply in terms of its effects, that's going back to that instrumental conception of law. And that what's interesting about legal history is that it's able to recognize what law does in its activity as distinct from its effects, and also what law does in its activity, which is still a what in some sense, and a noun in some sense, but different from the propositional rules or the objects that I think that either professional legal academy or some kinds of philosophers of law make law be, right? So the interesting thing about legal history is it can hit all three of those.
Sorry, I just wanted to add, perhaps personally, what the formulation means to me, or meant to me, as a way of both creating law and as a problem by imagining something else, another standpoint from which to examine it, but also that law as, in my view, or in my mind, and I'll state it sort of boldly, is intended to call into question our constructions of phenomena as relational, that is, as conjunctive or disjunctive. And hence, I think, when we begin to talk of agency and resistance and such concepts, those concepts become problematic too, because far and away the most common ways of thinking about agency, resistance, and so forth, very popular terms for historians for quite a long time, is precisely that they are relational. They reconstruct them relationally. We think of them relationally in terms of one thing in terms of the other, one thing in relation to the other, as requires me to think, if I want to think about agency, I need to think about it differently than relationally. That is part of, as it were, the project. I mean, it's horrible to say, let's have a conference, and the conference is going to have a project, and at the end of it, we'll all be somewhere different than we were before, and so on and so forth, when really the objective is to bring an audience into contact with a bunch of interesting papers and see what happens. So you kind of put a label on it. But the label does have some resonance, I think. It does have some purchase, and that is the resonance it has for me.
I just wanted to say one little thing, which is that in response to Catherine's question, that if you think of the pragmatic moment as being the moment of the triumph of relational thinking, right? So it's Herbert Spencer that really sort of creates modern relational thinking for social sciences, certainly the Anglo-American world at this point in time. It's interesting that it's only after Spencer that in the 1930s there's a conference held at Harvard Law School on the future of the common law, and Bound's paper is actually called "What is the Common Law?" Right? Which in fact is not a question that anyone is really asking, at least in that way, in the 19th century. So I think that could be one way of thinking that.
It is now 1:15. Am I supposed to be policing time, or is
it depends on how hungry
whatever?
everybody
If
is.
one could.
It would be better not to continue indefinitely. Obviously, it would be. We can. Let's go for another.
I'm looking at an audience that wants to.
Had his hand up.
Sorry,
that's shy.
No, I'm hungry.
Okay.
Okay.